The House is called back to order. We're going to get back to business here. I'm going to ask the clerk to ring the bell. Clerk will read the caption to a group of privileged resolutions. The clerk will read.
Resolution by Representative Dollar, 45th, commending Taiwan for its relations with the United States. Resolution by Representative Williamson, 111th, recognizing and honoring the Corinth Christian Church on its 150th anniversary. Resolution by Representative Ash, 56th, recognizing Norma Adams, Executive Director of the Georgia Association of Homes and Services for Children. Resolution by Representative Manning, 32nd, recognizing September 25th, 2012 as New Georgia Day at the Capitol. Resolution by Representative Dollar, the 45th, recognizing and commending Tritt Elementary School. Resolution by Representative Dollar, recognizing and commending Timber Ridge School. Resolution by Representative Dollar, recognizing and commending Mount Bethel Elementary School for outstanding contributions. Resolution by Representative Dollar, 45th, recognizing and commending Walton High School for its outstanding education. Resolution by Representative Dollar, the 45th, recognizing and commending Dickerson Middle School for outstanding contributions to education. Resolution by Representative Dollar, 45th, recognizing and commending Hightower Trail Middle School. Resolution by Representative Dollar, the 45th, recognizing and commending Dodgen Middle School. Resolution by Representative Dollar, 45th, recognizing and commending Rocky Mount Elementary School for outstanding contributions to education in the state of Georgia. Resolution by Representative Dollar, the 45th, recognizing and commending Shallowford Falls Elementary School. Resolution by Representative Dollar, recognizing and commending Pope High School for its outstanding contributions to education. Resolution by Representative Dollar, the 45th, recognizing and commending Murdoch Elementary School for outstanding contributions to education. Resolution by Representative Dollar, 45th, recognizing and commending Eastside Elementary School. Resolution by Representative Ralston, 7th, recognizing and commending Gilmer County Chamber of Commerce's 2011 Citizen of the Year, Lex Rainey. Resolution by Representative Smith, 70th, recognizing and commending Miss Martha Collins Lynch Moultrie on her 100th birthday. Resolution by Representative Smith, 70th, recognizing and commending Dr. Cindy Bennett, being named 2011-2012 National Outstanding Middle Level Assistant Principal. Resolution by Representative Mosby of the 90th, recognizing March 2012 Professional Social Workers Month at the Capitol. Resolution by Representative Mosby of the 90th, recognizing and commending Life South Community Blood Centers and 5 Points of Life Foundation. The resolution by Representative Stevens, 164th, recognizing and honoring members of the St. Patrick's Day Parade Committee, Chairman Michael Foran, Grand Marshal, 2012 St. Patrick's Day Parade, Timothy Tim Ansley, on the upcoming occasion, 2012 St. Patrick's Day Parade in Savannah, Georgia. The resolution by Representative Amerson, 9th, on the life and work, Mrs. Madeline Kiker Anthony. Resolution by Representative Brooks, 63rd, on the life and memory of Arthur Joseph McClung, Jr. Resolution by Representative Hughley, the 133rd, commending the Links Incorporated, recognizing March 14, 2012, Links Day at the Capitol. And a resolution by Representative Buckner of the 130th, recognizing and commending Ms. Jane Starnes through the privilege resolutions.
Is there objection to adopting the privilege resolutions? The chair hears none. The resolutions are adopted. The chair has been advised that we have a new member of the House. That Representative Stacy Evans has given birth to a little girl at 11:41 a.m. today. And Ashley Blaine is 7 pounds and 11 ounces, and all doing well. We're going on to the back to the rules calendar. Clerk will read the caption to House Bill 751. House Bill 751.
House Bill 751 by Representative Holmes of the 125th. A bill of entitled act provide that future elections, office of probate judge in Jasper County shall be nonpartisan elections, provides for submission of this act for preclearance under the Federal Voting Rights Act of 1965. Bill having been for the House Committee on Intergovernmental Coordination bill, the committee recommends the bill do pass, and the bill is being read today for the third time.
Chair recognizes Representative Holmes to present the bill.
Thank you. Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring before you today House Bill 751. This bill provides that future elections for the office of judge of the probate judge of Jasper County to be nonpartisan. I ask for your favorable consideration on House Bill 751.
You have no questions. The lady has yielded the well.
Thank you. I yield the
Is
will.
there any
Thank you, sir.
objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 751 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? All members voted. If so, the clerk will lock the machines on the passage of House Bill 751. The ayes are 130, the nays are 15. This bill, having received the requisite constitutional majority, is therefore passed. The clerk will read the caption to House Bill 898. House Bill 898.
House Bill 898, Representative Earhart of the 36th. A bill to be entitled Act to amend Title VII relating to banking and finance so as to enact the Georgia Merchant Acquirer Limited Purpose Bank Act. Provide for definitions, organization, control of merchant acquirer limited purpose banks. Provide for promulgation rules and regulations. Prohibit certain fees. Provide requirements for articles of incorporation by merchant acquirer limited purpose banks. Provide for minimum requirements to operate as a merchant acquirer limited purpose bank. Provide for permissible activities of a merchant acquirer limited purpose bank, and to provide for enforcement of rules and regulations. The bill having been for the House Committee on Banks and Banking, that committee recommends the bill do pass by substitute. The bill is being read today for its third time.
Chair recognizes Chairman Earhart to present the bill. Chairman Earhart.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring for your consideration House Bill 898. This is a proposition from the Banks and Banking Committee. Chairman Morris and I are bringing this to you. It's somewhat of a dense banking terminology legislation, but I'll tell you what it really does. It establishes and allows companies in the merchant acquiring credit card business to establish a bank. These are special purpose banks. Georgia has several large processors with thousands and thousands of credit card processing jobs here in the state, and most of the merchant authorizations conducted anywhere in the world go through these Georgia companies. We want these Georgia companies to be able to do business here and to continue their banking business here, and that's why it makes good sense to put together a special purpose bank overseen by the Georgia Department of Banking that will allow them to do business with banks in Georgia. This is what we want to do, and it does. This is not a retail banking situation whatsoever. They can only accept deposits from owners of the bank. They do not operate with the general public under any circumstance. Again, they're regulated by the Georgia State Banking Department. The department has signed off on this proposition. The activities of a merchant acquirer, they're on page 2, and this is a world of credit cards. You know, when you swipe your debit card, your credit card, those types of things, this is what they do. They do those transactions. They provide the means to authorize those valid transactions and such. It's very specialized. It's a one-purpose thing. This company or companies would have to also dedicate 50 jobs in Georgia to the operation of such a limited purpose bank. And these are two very good propositions. They have to pay all the cost incurred to the Georgia Department of Banking for any application or investigation process going through the charter, and they pay all the cost incurred to the Georgia Banking Department for any oversight, regulation, or examination. They also have to be on a safety and soundness measure at least a $200 million or more in capital. Mr. Speaker, again, a fairly dense but simple proposition. I ask the House to favorably consider House Bill 898.
You have no questions.
I yield the will.
Gentleman has yielded the will. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair has just been made aware that there was a minority report filed to this bill. Does the minority report author wish to speak on the measure? Does anyone wish to pursue the minority report? It's waived. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of passage of House Bill 898 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of House Bill 898, the ayes are 135. The nays are 20. This bill, having received the requisite constitutional majority, is therefore passed. The clerk will read the caption to House Bill 520. House Bill 520.
House Bill 520 by Representative Parsons, 42nd, a bill being entitled Act amending Code Section 46356 relating to requirements to purchase energy from a customer generator and safety standards and regulations so as to change the amount of energy an electric service provider is required to purchase from an eligible customer generator. Bill having been before the House Committee on Energy, Utilities, and Telecommunications. Committee recommends bill do pass. The bill is being read today for the third time.
The chair recognizes Chairman Parsons to present the bill. Chairman Parsons.
Thank you, Speaker. Ladies and gentlemen, House Bill 520 modifies legislation or law that we enacted about 10 or 12 years ago. And what that did was set up a process that the electric providers in the state would buy back renewable energy from people that were able to generate it, and set up that it would be bought back at the avoided cost that it would have cost the electric producing companies to produce that with traditional types of generation. And set up a percentage, percentage of the total electricity that was sold the year before, and the percentage was like 0.2%. And all this bill does is raises that percentage. It doesn't change the fact that the cost to the electric company is still the avoided cost. That's just what it would cost them to produce that electricity if they produced it with traditional sources of power, coal or gas. So they're buying back electricity, solar, or it could be biomass that is cleaner and conserves traditional sources of energy. And this raises the percentage from the total electricity that electric company produced the year before to 2.5% of that total electricity. And that's really all it does. It's a good clean energy bill. The electric providing companies are for it, and it shows that Georgia is serious about clean air and clean energy and helping save our environment. I would appreciate your favorable consideration. And Mr. Speaker,
You have no questions.
I yield the will.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 520 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of House Bill 520, the ayes are 149, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. The chair wants to remind all the members that if you wish to speak on a bill, then you need to sign up in order to do that so we can properly allocate time and plan effectively. I'm not encouraging you to speak on the bill. I'm just saying that if you wish to, you need to sign up, pro or con. Clerk will read the caption to House Bill 863. House Bill 863.
House Bill 863, Representative Hatchett, 143rd. A bill will be entitled, Act entitled 50 relating to state purchasing, change certain provisions relating to purchases without competitive bidding, central bid registry, procurement cards, rules, regulations, applicability to emergency or purchases, and the Purchasing Advisory Council. Change short title, change certain provisions relating to definitions relative to small business assistance. Bill has been before the House Committee on State Institutions and Property. The committee recommends the bill pass by committee substitute, and this bill is being read third time.
The chair recognizes the governor's floor leader, Representative Hatchett, to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you House Bill 863, the Small Business Assistance Act of 2012. This bill invites small business to do business with the state of Georgia. House Bill 863 addresses how purchases are made by state agencies through the Department of Administrative Services. It'll promote small business sales to the state. There are two main issues with this bill. House Bill 863 raises the no-bid small value limit from $5,000 to $25,000. This represents only purchases not available on state contracts or statutorily required. This limit was last raised in 2000 and will align us with other states like Florida and Tennessee, just to name a couple. Raising the limit to $25,000 will allow agencies to respond quicker to advantageous pricing opportunities, since the burdensome bid process will not have to be used. The total amount of purchases in fiscal year 11 between the $5,000 and $25,000 range totaled $251 million. That's $251 million that small business will now fight for, increasing competition and driving prices down. Agencies lose money when they can't react quick enough to capture these deals for large ticket purchases because those deals don't stick around for weeks. The Department of Administrative Services will reemphasize the expected behavior in the new guidelines for spending for agencies and will monitor and audit purchases through their e-procurement system. Agencies must still abide by budgetary authority levels of spending. Now, item 2 and issue 2 in the bill, DOS will still use the formal bid process for purchases over $25,000 and will still have in place the state mandatory contracts. To assist small business and include more purchases being made from Georgia small businesses, this bill updates the definition of a Georgia small business when used as a preference in the bidding process. This definition was last updated in 1975. The definition will now include, if this bill is approved, a Georgia residency requirement. It raises the number, as amended, of employees, the limit of employees to 300. It raises the limit of gross annual revenue to $30 million. Raising these limits includes more business involvement in the bidding and can ensure that the state is purchasing from Georgia companies. It will allow the Department of Administrative Services to break out state bids regionally, making small businesses more able to comply with the bid. Small businesses have historically been underrepresented in state contract opportunities. In keeping with our red tape watch to reduce burdensome regulations on our state, this bill does that and opens up the ability to do business with Georgia. This bill will grow Georgia small business. A vote yes will tell Georgia small business that the state wants their business and we want to do business with them. I ask for your favorable consideration of House Bill 863. Mr. Speaker, if there are any questions, I'll be glad to take them.
You do have a couple of questions.
Thank you.
Do you yield?
Yes, sir.
Chair recognizes the Chairman of the Higher Education Committee, Chairman Rogers, for a question to your right.
To the gentleman in the well, do you yield?
Yes, sir.
Isn't it true raising this will allow you to sell more ice cream to state agencies or schools without going through a bid process? Isn't it true that now you can do it up to $4,999, and now this will allow you to do it at $24,999?
I hope of what the gentleman states is true.
Thank you.
You have further questions. Do you yield?
Yes, sir.
Chair recognizes Representative Smith to your left for a question.
Thank you. Does the gentleman yield?
Yes, sir. Thank you.
Thank you very much. Just like a point of clarity, if you may. You mentioned on this Bill 863 that 300 employees, less than 50 million, raised from 1 million. Now, in the state, which is typically in all states, there is a program called DBE, Disadvantaged Business Enterprise Programs. They can have a limit of up to $999,000 for less than $1 million in small businesses. Will this amendment be put in place so that DBEs will be able to be a part of this as well?
If they are working with the Department of Administrative Services and through the department, then they will be included in that.
Thank you.
Thank you.
Do you yield for further questions?
Yes, sir. I'll take one more.
Uh-oh. Chair recognizes the Chairman of the House Appropriations Committee, Chairman England, to your right for a question.
Does the gentleman yield?
Yes, sir.
Is it not true that these purchases will still be audited by DOAS?
Yes, sir. They audit through the e-procurement system, and they also do an audit every year.
Okay, makes me feel much better. Thank you.
Thank you. Mr. Speaker, there are no further questions, I'll yield the will.
Well, you do have further questions, but he has yielded the well. Chair recognizes the Vice Chairman of the Minority Caucus, Representative Thomas, to speak to the bill. I'm sorry, Mr. Chairman, the Chairman of the Minority Party Caucus, Representative Thomas.
Thank you, Mr. Speaker. I rise this afternoon because I have some concerns with the direction that we intend to go with this bill, even with the amendments. I understand the need to enlarge and to make the cap for a no bid hire. No issues with that at all. My concern, however, is if it's true that this state has historically seen small businesses underrepresented in the business that's done with the state or local governments, the best way to change that is not to redefine what a small business is. It's to actually encourage the use of small businesses in a better way than apparently we've been doing to date. Now, I do not work for a small business. I work for a large national corporation, so I don't have any dog in this fight directly. But when you're defining, according to the amendment that's been offered at least, if you're going to change the definition of a small business from current law, which is fewer than 100 employees and less than $1 million in gross income, if you're going to change that so dramatically to 300 employees, which I believe is what the amendment offers, or from $1 million to $30 million, are we really talking about small businesses any longer? I'm not sure what the motivation for this bill is. I mean, we often come down and hear presentations of bills that tweak a little something. Sometimes we're real upfront about it, sometimes we're not. I mean, if there's somebody we're trying to help, let's just call it the I'm helping my friend so-and-so bill to make sure that they're a small business. And I don't know if that's the case, but it's just hard for me to understand another justification for so dramatically changing what constitutes a small business in Georgia. What is small is small. The people who we're really trying to help are those small businesses which, under current law, are under $1 million in gross receipts or under 100 employees. Those are the folks that are actually creating future jobs. They are the drivers of our economy. They have a hard time getting started because they don't really have their hooks into the marketplace that well, and these small business requirements or allowances that the state offers gives them some way to grow, to get started, so they can become a medium or a large business. But when you redefine what a small business is, tell me, how is a company with under 100 employees and under $1 million in gross receipts going to compete with a 300-person company with $50 million in revenue or $30 million in revenue? I don't know. I just wonder why the changes. We heard no justification whatsoever other than we want to see more small businesses succeed. But all you're doing is changing the definition of what a small business is. And with a magic wand, yeah, a lot more of them are going to succeed because a lot more of them are going to be making a lot more money at the expense of what are really and truly small businesses. So I ask you to vote against this proposition. I really think it is going to harm small businesses in this state. It's not something that's going to advance employment. You're not going to see the kind of growth that we really rely on our small businesses to provide. It's just not the right direction for this state. Thank you, Mr. Speaker. I yield the will.
You have a question if you care to yield. The gentleman does not yield. Is there any objection to the previous question being ordered? What purpose does Representative Hatchett rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that Small Business Administration's general definition of a small business is 500 employees, and this bill is less than that?
I'm sure the gentleman believes that to be true.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the amendment? That's Amendment AM 251274. Any objection to adopting the amendment? The chair hears none. The amendment is adopted. Is there any objection to adopting the committee substitute as amended? The chair hears none. The committee substitute as amended is adopted. Is there any objection to agreeing to the report of the committee which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 863 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 863. The ayes are 128, the nays are 38. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 641. House Bill 641.
House Bill 641 by Representative Willard of the 49. A bill to be entitled Act Title 15 relating to courts so as to substantially revise, supersede, modernize provisions relating to juvenile proceedings, provide for the Office of Child Advocate for the protection of children, amend Title 49 relating to children and youth services, provide for an appeal procedure when the Division of Family and Children Services of the Department of Human Services fails to provide aftercare and transitional services to certain children. Provide for the Department of Human Services to provide for performance measures for an independent living skills program, to amend the official code of Georgia annotated so as to conform provisions to the new Chapter 11, Title 15, and correct cross-references. Bill having been before the House Committee on Judiciary, that committee recommends that this bill do pass by committee substitute. Bill is being read today for the third time.
Chair recognizes Chairman Willard to present the bill. Chairman Willard.
Thank you, Mr. Speaker. To my colleagues, I want to start out with a matter that I think we all have had, and that is people will quite often address us as elected House members and say, why do you do that? Why do you run for office? What is it you see you're doing or gaining by being a member in an elected body like this, the House? And I try to explain to them that those of us who are down here are doing it for a purpose of service, certainly to our state, but we like to see what is good policy being made for the people of Georgia. I think that's a major criteria. And I raise this point because I want to lead into the bill that this is probably one of the more important pieces of policy legislation you will have before you this year. It has been a bill that's been in the making for 5 years. We have not had what I call a substantial review and overhaul or revision of our juvenile laws and juvenile code since back in the early 1970s, over 40 years ago. We have a lot of things that were in the law from back then as practices and policies that we recognize have been outdated. They are not meaningful today. We're not really addressing, as we should be, the issues of how to take care of children in trouble. And that is one of the things that this bill is doing. It is taking policies that have been recognized in other areas as serving good to the improvement of children who are in trouble. And I say by trouble, not only delinquency, but children with deprivation, children who are abused. These are children that come before our juvenile courts and are in need of the court's oversight and attention. The bill is a comprehensive rewrite of the entire juvenile code. It doesn't mean everything's replaced. What we have done, though, is taken the code that we have and put it into a more succinct, understandable document that can be followed by practitioners in the area of juvenile law and by the courts. The bill has the support, and I'm going to read off a list of names here. The Council of Juvenile Court Judges has endorsed the bill. The Prosecuting Attorneys Council of Georgia endorses the bill. The Georgia Association of Criminal Defense Lawyers endorses the bill. Georgia's CASA, which is the group that does a lot of volunteer work as guardian ad litems before the court, they endorse the bill. The Child Advocacy Centers of Georgia endorse the bill. The Department of Juvenile Justice, to whom we entrust the care of these children, endorses the bill. The Department of Human Services, which provides a lot of the day-to-day financial support and needs of children in trouble, endorses the bill. The Department of Behavioral Health and Developmental Disabilities, who is going to play a major role under this bill because of the needs that sometimes children have with disabilities, they endorse the bill. The Association of County Commissioners of Georgia, the attorney who represent children and parents in abuse and neglect cases, and the youth who have been throughout this state in foster care and juvenile court systems, and many, many more. Ladies and gentlemen, the bill is divided up into 13 chapters, and what we're going to do at this point, if I may ask for the chair's indulgence, Mr. Speaker, there are a number of individual House members who have been involved with the bill who would also like to address the House with their support, and what we've done is divided up the various articles of the bill for these individuals to speak to the House. And Mr. Speaker, what I will do at this point in time is yield the well, but ask for the chair's opportunity to let me come back and again close out addressing the House and answer questions that House members may have about this important legislation. With that, Mr. Speaker, I will yield the well.
The chairman has indicated that he wants to hold yielding for questions until his final summation, and he has that right. He yields the well. I expect we'll see him back again on this measure, whether we want to or not, right? Chair recognizes Representative Collins to speak to the bill.
Thank you, Mr. Speaker. I am going to be addressing just a few of the changes in the Article 1 and Article 2. This is a definition section, and I just want to highlight some terms. As the chairman said, he will be back to answer specific questions. But I think in a bill like this, when we're looking at a long-term change and something that I think is very positive in this area, especially for those who practice law and also the families that are actually impacted, I think these are things that I'm pleased to speak about. Several definitions found in Article 1. You can look through the bill, and it is abuse. The current juvenile provision did not include a definition of abuse. House Bill 641 provides a clear definition of this term. We also changed dependency. We take deprivation out and change it to dependency. I had a question about this early on, why, but this is the standard that is used across all other states, and we're using the term dependency coming in. Imminent danger is also defined here. The definition helps clarify the level of threat that justifies the removal of a child from his or her home. This actually, again, in my mind, gives better protection to both the family and the child. They have a better, clear definition of what that actually means. It also requires, as far as definitions of parties, it gives a better definition of that. It also requires that whenever possible, the same judge should preside over all proceedings involving a particular child or family. This provides continuity through the system. Many times this is not possible, but when it is possible, we want to see continuity because one judge can better look at the case from start to finish and other aspects that may come in. Also, the courts to consolidate proceedings if the same child is alleged to be both abused or neglected and delinquent in need of services. This happens several times when you have a child that is both being abused but also at the same time has issues where they are being charged as well. So this allows the consolidation of those cases. This saves time and court costs and reduces the strain on families that come in after having missing multiple days in court. The bill in Article 1 also encourages mediation. For those of us in law practice, mediation is a good cost-saving alternative than the continual litigation that causes many times in our courts and especially in our juvenile courts. We believe that mediation is an effective way of reducing those costs and promotes faster resolution. Also, it is, and this was changed in committee, and you need to hear this, the best interest of child is made parallel to those that are also found in Title 19. So best interest of child is now uniform across the code, and that would be something that's effective. Article 2 simply deals with governance and the administration of the juvenile court system and makes basically stylistic changes, and that is all. Mr. Speaker, I'll be yielding the well at this point for the next speaker on this bill.
You have no questions. Chair recognizes Representative Oliver to speak to the bill.
Thank you, Mr. Speaker. I'd like to begin by personally giving thanks to Chairman Wendell Willard for his mammoth, extensive amount of work on this very important bill. It really takes someone with dedication to particular details to bring several years of work together for a model code revision. I'd also like to say that model code revisions, code revision bills of big sections of the law do require private partners, and the State Bar of Georgia and other nonprofits have contributed financially extensively over the last 5 years to this effort. I would like to address Article 3 of the bill, which is page 40 to 90 in the House Bill 641 that is before you. This is the area of the law that deals with abuse and neglect, and specifically it's an area of law that is governed by the United States and Georgia Constitution about when the state of Georgia may interfere with a parent's right to be a parent, and secondly with an extensive amount of federal legislation that defines the processes by which children may be removed and receive federal funds, as Georgia does. The purpose of these statutes is to make sure that the state can operate efficiently, quickly, and with the goal of permanency, so the child may be returned to the family in a safe setting or made a permanent placement through adoption or permanent guardianship. Specifically, in these sections, we have shortened the time frames for the first review of cases from 90 to 75 days. We've shortened the timeline for permanency planning hearings, again to bring Georgia into compliance with federal statute. We have made a slightly different timeline for younger children, children under 7. We know from research and we know from our practice that children who can be removed and placed permanently at a young age and not left in foster care for many years is incredibly important. We provided for specific discovery sections in 641, which allow lawyers more efficiency and flexibility in actually trying a case. And we removed the time limitations on temporary custody orders, which is something the juvenile court judges have wanted for some time. The federal law of 2010 reauthorizing Child Abuse and Prevention Treatment Act also includes new circumstances whereby the state is not required by law to first go to reunite the child with a parent. Specifically, we do not have to go to attempt reunification where the parent is convicted of a sexual offense or is required to register as a sexual offender. Thank you, Mr. Speaker. Thank you for your favorable consideration.
Lady has yielded the well. Chair recognizes Chairman Jacobs to speak to the bill. Chairman Jacobs.
Thank you, Mr. Speaker. It's always good when you have a 245-page bill to break it up and hear from different members on different sections. So I am happy to speak to Article 4 of the bill, which is on pages 91 through 108. Article 4 of the bill strengthens the procedural protections that exist for parents in the termination process. It also makes, in the termination of parental rights scenario, certain rights of the children clearer. It is an improvement upon the existing law in that regard. First of all, it makes clear that until a child is adopted by another family, that child still has the right to inherit from his or her natural parents. Until the child is finally placed and adopted by another family, it preserves the relationship of the child with his or her siblings and his or her natural family. In addition, it shortens the period of time that a court looks back to determine if there has been a problem with the parent whose parental rights are being terminated, whether those parents have developed and maintained a bond with the child, provided support, and complied with the court-ordered reunification services process. And what that does is, obviously, if in a shorter period of time, if you have parents that have been taking care of their children, we want to give due consideration to that. And so the bill strikes a very good balance in that regard in shortening that period of time. Also, in addition, if a child is unlikely to be adopted, the child can have his or her, if a child is unlikely to be adopted, the child can petition to have the parental rights of the natural parents reinstated. Now, there are safeguards on that. You still have to inquire into whether the situation in the natural family's home has been remedied, and in addition, that determination still has to be made in the best interests of the child. But it does strike a very good balance to help preserve and protect the rights of natural parents, and also allow some safeguards for children who are caught in this system. I will say that I was thoroughly impressed during the hearings in the Judiciary Committee and just how many stakeholders came together to make this bill a reality, between the state bar and lawyers who practice in this area, and the juvenile court judges and advocates. It is a very strong effort. It's a very long bill, and so I do ask that you pay very close attention to the fact that you have a lot of stakeholders who have come together over a long period of time to make this happen. And with that, I will hand off to whomever is handling Article 5, but I do ask for the House's favorable consideration of the Juvenile Code rewrite. It's a good piece of legislation, and I ask for the House's favorable consideration. Thank you, Mr. Speaker.
Chair recognizes Representative Stevenson to speak to the bill.
Thank you, Mr. Chair. I rise today to not only support this bill, but to praise the committee from which this bill came out of, and will ask for your consideration at the end. I am going to describe and speak to Article 5 of the bill, which starts on page 109. It is a completely new set of provisions that's intended to ensure that dependent children in foster care, and that is a major part that makes this bill all come together in continuity, that are given the opportunity and assistance to plan for their own futures and learn the necessary skills of independence and to set goals. We all know that children who age out in foster care tend to struggle, including high rates of homelessness, incarceration, and lower rates of educational attainment. That is because at that age, they have no family units. Specifically, Article 5 addresses these requirements. It requires the Division of Family and Children's Services to develop procedures to assure that children in foster care can participate in age-appropriate opportunities such as extracurricular school activities and even things that we take for granted, but things like sports. It also provides children in foster care with support to plan for their future. The children will receive help from caregivers, caseworkers on setting educational and career goals, guidance regarding the steps necessary to achieve those goals, and with possible offered internships and work-related opportunities. The third mandate is an individual assessment of the services each child shall receive so that the services reflect the individual's needs and goals, meaning that they will correlate uniquely to what each individual child may need. The bill will also mandate aftercare services for the young adults age 18 to 21. That's going to include mentoring, tutoring, mental health services, substance abuse services, temporary financial assistance. Additional transitional services will also be made available to the age of 23 to meet the critical needs of the young adults who were in foster care or in subsidized transitional living arrangements when they aged out at 18. The bill finally in Article 5 provides judicial oversight of the independent living services. For children between the ages of 14 and 18, judicial review will occur as part of the usual dependency review and permanency hearings, with one additional hearing to be held within 90 days after the child turns 17. Judges will also review independent living services for the young adults between the ages of 18 and 23 at least once a year, particularly during that transitional services that is available up to age 23. This judicial oversight is a requirement for new federal funding under the Fostering Connections to Success and Increasing Adoptions Act. The new federal funding will cover most of the costs of Article 5 of this bill, which is, as I said, completely new. I would thank each and every one of you all for your favorable consideration of this bill. And with that, Mr. Speaker, I yield the will.
Lady has yielded the well. Chair recognizes Representative Dobbs to speak to the bill.
Thank you, Mr. Speaker, and ladies and gentlemen. I also rise in support of House Bill 641 and also wish to thank Chairman Willard and all those individuals that have spent countless hours working on this new code. I have been asked to highlight the parts of the bill in Article 6. Article 6 creates a new approach for intervening with children who are currently considered unruly. Children in need of services, or CHINS, often known as CHINS, include children who have committed an act that would not be against the law, but for the fact that they are children, such as skipping school, running away from home, and violating curfew. CHINS also include children who are habitually disobedient to their parents and place themselves or others in unsafe circumstances through their behavior. Currently, the court's intervention with these children is similar to the intervention in delinquency cases. This bill creates a more holistic, service-oriented approach to these cases. Specifically, it acknowledges that these behaviors happen and that the involvement of the family and other important people in the child's life is important to protect the child and help him or her become a responsible member of society. The bill provides that after a complaint is filed, the court's intake officer is to convene a multidisciplinary conference involving not only the child, his or her parents, but also DFACS and other agencies that has the authority to provide services to the family. It empowers participants in the multidisciplinary conference to create an informal family service plan agreement which identifies services and actions that will mitigate the child's inappropriate conduct and related problems with the family. It also includes the involvement of a DFACS caseworker that will be assigned to ensure that the plan is implemented. The article also permits the court's intake officer to waive this conference if he deems it inappropriate or futile. Or the case can also proceed to the court's oversight in the informal family services plan if it indeed fails or is waived. Finally, the bill also ensures compliance with the Federal Juvenile Justice and Delinquency Prevention Act by clarifying under which circumstances and for how long a child in need of services can be held in a secure detention facility. It specifically prohibits a child in need of services from being held in a jail or other detention facility intended for adults. And it limits the total time a child in need of services can be held in secure detention to no more than 24 hours before a court hearing and 24 hours after, unless certain circumstances apply. This article responds to children who commit status offenses appropriately to begin with increased public safety by decreasing the likelihood that they will go down the path into serious offenses. Thank you, Mr. Speaker, and thank you for your favorable consideration to this bill, and I yield the will.
Lady has yielded the well. Chair recognizes the minority leader of this House, Representative Abrams, to speak to the bill.
Thank you, Mr. Speaker. I too want to thank Chairman Willard not only for the work that he's done on this bill, but for inviting some of us from Judiciary Non-Civil to play. I'm here to speak to Article 7, which relates to cases involving children who've committed acts that would be crimes if the children were adults. These acts are known as delinquent acts, and the cases are known as delinquency cases. Article 7 under the bill reorganizes and clarifies the delinquency provisions of current law and makes several substantive changes, including first and foremost providing that a child's right to be represented by an attorney cannot be waived by the child's parent. It can only be waived by the child after the child has had an opportunity to speak with an attorney, thereby providing and protecting due process. It requires a prosecuting attorney to file the petition and represent the state in all delinquency proceedings. It excludes statements made by a child during intake, screening, treatment, or evaluation from evidence, meaning that these statements cannot be considered by the court except as impeachment or rebuttal if the child tells a conflicting story. It incorporates requirements for the Federal Adoptions and Safe Families Act, which will allow Georgia to better access federal 4E funding for some delinquent children. It requires two types of risk assessment to aid courts in determining whether placing the child into secure detention is appropriate. Those two steps would be either detention assessment or behavioral health evaluation. It also retains provisions requiring the transfer of a case to Superior Court for adult criminal proceedings if a child over the age of 13 is alleged to have committed certain specifically listed offenses such as murder and rape. I know there has been a great deal of concern about the removal of that provision, and that provision has been retained. However, it does allow the Superior Court to transfer cases involving aggravated sodomy, aggravated child molestation, and aggravated sexual battery to a juvenile court for extraordinary cause. It provides more flexibility to judges in determining the length of sanctions for children adjudicated for a designated felony. Because currently, if a court determines that restrictive custody is necessary, the child must be committed to DJJ for 5 years at an annual cost of $76,000 per year, and the child must serve a minimum of 1 year in confinement, followed by at least 12 months of intensive supervision. Instead, under this new bill, instead of mandating set timeframes, the Act permits commitment to DJJ for a period of up to 5 years, of which a minimum of 6 months may be served in restrictive custody. This protects the court's ability to provide stiff penalties where appropriate, but also allows judges to tailor more individualized responses for low-risk offenders. I ask for this body's favorable consideration of HB 641, and I yield the well.
Chair recognizes Representative Weldon to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, I want to congratulate the Chairman Willard, for getting this bill to where it is now, and I'm going to ask for your favorable consideration. I'm going to present Section 8 of the Juvenile Code rewrite. That begins on page 182. It goes through page 190, beginning on lines 6282. This article governs the way courts determine the competency of a child, and it also governs the way that a child that's involved in a delinquency matter is defended and how his competency is determined. This is important because it's related directly to the due process that allows people to preserve their rights and their liberties, and children are definitely entitled to that under our Constitution. Article 8 revises current law regarding competency in juvenile proceedings, particularly in that it requires that a child under the age of 13 is accused of committing a serious violent felony. The court must order a competency hearing and before the delinquency proceeding can proceed. And before any administration of a competency evaluation, an attorney will be appointed to the child if they've not already represented by an attorney. The court will be able to accept a stipulation as to the child's competency rather than order an evaluation when there's agreement between the parties and the child has spoken to an attorney. This also provides that different responses, depending on whether it's likely that an incompetent child is likely to, at some point in the future, because of maturity or treatment, become competent. Current law uses the same framework for all incompetent children, but this bill provides that when a court finds that a child is unlikely to become competent to stand trial, it must dismiss the delinquency action and appoint a plan manager in order to and order that a comprehensive service plan be instituted for the child. If a child has been found to be incompetent due to their age or immaturity, this is for those very young children, then it must dismiss the delinquency, to become, but they will be, or they are expected to become competent eventually, but not in the very near future. The same approach will apply. If the child is currently incompetent but may attain competency with services, the court will have the discretion as to whether to order remediation services, and factors where added that the court should consider in determination whether services are appropriate. Progress reports will be submitted to the court, and the court will monitor the progress of the child through the competency proceedings. I'm going to ask for your favorable consideration of this bill. Thank you.
Gentleman has yielded the well. Chair recognizes the Majority Caucus Whip, Representative Lindsay, to speak to the bill.
Hopefully. All right. I won't try to deceive you and try to say this is a simple bill. However, it is a very important bill, and I want to cut my time short so that we can get the chairman of this committee, who's worked so very hard on this bill, back up here to answer any questions that you have. The most important part of the bill, and the section that I'm going to talk to you about, is in Article 13 of the bill, which creates a commission that actually takes a look at the bill, at the juvenile code periodically, and recommends updates. One of the problems that we have had is that the last time we've had an overhaul of the juvenile code was about 40 years. And that's a little bit better than the evidence code, because the last time we had an overhaul of the evidence code before last year was 150 years. But we're going to try to cut that even shorter. We're going to set up a commission that's going to periodically look at the law and see how it's being used, see what areas need to be tweaked, and come back to the General Assembly on a periodic basis with recommendations to update the code even further. It's something very similar to what we've already do with the Child Support Commission that's done an excellent job keeping our child support laws up to date. We also have an advisory board to the Workers' Compensation Board that does the exact same thing. These boards have worked extremely well for us in terms of keeping our laws up to date in very critical areas. And that's all this commission does. The commission does have a sunset so that if it doesn't fulfill its purposes, it will be automatically dissolved in 12 years. Mr. Speaker, I yield the well and turn it back over to the chairman of the committee.
Gentleman has yielded the well. Chair recognizes the chairman of the Judiciary Committee, Chairman Willard.
Thank you, Mr. Speaker. I'm going to be brief, ladies and gentlemen. I want to touch a couple of things. We got to recognize the great work that our juvenile justice system does in Georgia with what they have as far as resources. As is pointed out, I think by one of the earlier speakers, each time we put a child in state custody, it costs the state $200 a day. Imagine doing that with someone in college. You can send somebody to Harvard and do better as far as the outcome. I want to talk about the cost, because I've had several people address this, and we had a great deal of discussion about cost. No one can say specifically what the cost is. I've asked for departments, I've asked for the prosecuting attorneys, defense counsels to give me some figures. They come in all over the range. This bill does not become effective, ladies and gentlemen, until July the 1st, 2013. We're putting the policy in place by your approval of this bill and then the Senate's approval. The governor is very supportive of it. And in talking with the governor's staff, we recognize there will be some upfront costs to go through a major change in how we are taking care of children, whether it be delinquent or children in need of services in the state. And this bill is trying to address those type of needs. And we're going to do an empirical study as best we can of those costs between now and next January and come back to this General Assembly with a full explanation of the cost. The bill calls now for things we have not had to pass. That is, that any state case being presented because of delinquency issues must be done through a prosecuting attorney. It also provides that the child, just like we do for adults, will be represented by an attorney for this defense. But it also does something I think is a great step. Where we have children who are having problems, we're going to have that child given what is known as a risk assessment. That risk assessment really is going to try to go to the core of what is causing the child to conduct themselves as they do, whether it be delinquent matters or children in need matters, unruly, etc. So that is a part of the program. It's a great program. And I say to you, we have maybe some additional costs up front, but the big thing is going to be the savings we will realize over the years by not having these children always locked up, and the fact that we may save some children's lives as far as their future from it. I think that is an important part of it, big part of it. Mr. Speaker, with that, I'm going to stop comments and I will take questions from the members.
You have a couple of questions if you care to yield.
I will yield.
Chair recognizes Chairman Rice to your left for a question.
Yes, sir.
Thank you, Chairman Wood. Appreciate all of the people who worked hard on this over, I know, a number of years. Is it not true that most of the Gwinnett delegation got letters from the district attorney indicating that the cost of the county was going to be someplace around $700,000 or $800,000?
I'm not sure that, I'm sorry, I understand there has been some communication. I can tell you that that is not the case. There's no known amount, but point out this fact. The state is going to step up and do funding in conjunction with the local governments. The usual support of the juvenile court system throughout the state, as far as the court itself, is a local obligation. The state supports the juvenile justice system itself, as far as the department. We will be able to say that yes, there's be some costs, but I again say because of the things that we're going to be doing, I think the overall savings will be much greater in time.
Would you yield for one more question?
Yes, sir.
Based upon what you're saying and what's going to happen in 2013, is it true then that we would potentially see some of the $200 a day that goes into the expense of maintaining these kids that the state pays go into an amended budget for 2013 or the 2014 budget?
I think the cost will be going down if we don't take as many children into state custody. And what I see happening is there will be what I call community houses set up, doing much as we're trying to do with our adult system of corrections and try to keep people in the community. We're trying to keep the children in the community, keep in school. After school, they'll go to this community house where they'll have tutoring, help them with their lessons. They'll stay there till bedtime, then be allowed to go home. It'll be like a probation program.
Is it not true that I agree with the tenet of the bill, but I will look next year for an opportunity to see the financial implications?
We will, and I think the point is making now, we put in place the preparation of policy now, and then we start preparing what that cost is going to be and address that next January. Thank you, sir. Any other questions, Mr. Speaker? If not,
you do have more questions. Do you yield?
I will take a few more. I know the time is precious.
Chair recognizes Representative Byrd to your right for a question.
Thank you, Ms. Byrd.
Does the gentleman yield?
Yes, I do, Ms. Byrd.
First, I want to thank you very much for all your hard work on this bill and everyone else that was a part of it. But I do have some concerns. Is it not true that DFACS has been in the news lately because of the upswing of kids' deaths in Georgia?
They certainly have, and it's been an ongoing, long time situation.
Thank you. Do you further yield?
Yes, ma'am.
Is it not true that DFACS has a shortage of caseworkers right now?
I'm not sure I agree with what the ladies, whatever the lady speaks on that.
Do you further yield?
Yes, ma'am.
I'm concerned about Article 5 on pages 111, and it lays out a plan for DFACS to develop, to provide training, to develop procedures, implement. If they are not able to do their job now, how are they going to be able to do all of these new things listed in this bill, please?
But these are things that really are currently ongoing in some parts of DFACS, maybe not statewide. But I want to also point out the fact what we will have here is court oversight, which has not been in place at the present time, and meaning that the court's going to have these matters brought back on a periodic basis to review the fact that DFACS is accomplishing the goals that are set out in these plans, and if not, direct that changes be made. So you haven't had the court's involvement in situations where they should have been probably overseeing how things are handled.
Do you further yield?
Yes, ma'am.
So it is my understanding now that the court is going to be involved with DFACS, that we are not going to have as many deaths of children that are in the custody of DFACS.
We can only hope that be the case. Ms.
Thank
Byrd.
you.
Thank you.
You have more questions if you care to yield.
I will at this time, Mr. Speaker, yield the well. I think everybody understands where we're going with this, and if I have someone who wants to ask me an individual question, I'd ask them to come to my desk. Thank you, sir.
That appears to be all those who wish to speak. What purpose does Representative Hextall rise?
Mr. Speaker, I apologize. I was going to ask the gentleman a question, but since he's yielded the
He
well,
has
that's
yielded
fine.
the well.
Thank you, sir.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 641 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 641. The ayes are 172, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed.
Thank you, Robbie. Thank you. Great job for it. Yeah. You got a sister there in the band. Thank you.
Trying to make sure I don't. You got it, partner.
Clerk will read the caption. Clerk will read the caption to House Bill 289. House Bill 289.
House Bill 289 by Representative Welch, 110th. The bill being entitled Act amending Title 48, relating to ad valorem tax exemptions, shows revised definitions, provides related matters to repeal conflicting laws. The bill having been before the House Committee on Ways and Means. Committee recommends the bill do pass by committee substitute, and this bill is being read for the third time.
Chair recognizes Representative Welch to present the bill. Representative Welch.
Good afternoon, ladies and gentlemen of the House. Thank you, Mr. Speaker. I present to you House Bill 289. Now, this bill is just about as complicated as the one we just looked at. And what I present to you is a population bill from Butts County. This is would be not prohibited under the law, but under our Constitution, we've allowed for population bills to extend if they were renewed in 1988. This one has been. This is one that's specific to Butts County, and I would ask your favorable consideration of the bill. If you have any questions, I'll yield for those.
You have no questions?
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 289 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 289. The ayes are 165, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 954. House Bill 954.
House Bill 954 by Representative McKillop of the 115th. The bill will be entitled, Amendment Title 16 relating to abortion, change certain provisions relating to criminal abortion, to change certain provisions relating to when abortion is legal, Amendment Title 31 relating to health, so it defines certain terms to require determination, gestational age prior to abortion, to provide for certain reporting requirements with respect to performance of abortions, state legislative findings, provide for related matters, provide effective days, repeal conflicting laws, and for other purposes. This bill having been for the House Committee, Judiciary and Non-Civil. Committee recommends bill do pass by committee substitute. This bill is being read today for its third time.
We are still on the rules calendar. We are still on the rules calendar. Members will remain in their seats. Chair recognizes Representative McKillop to present the bill. Representative McKillop, let me that's the understanding of the chair that pursuant to Rule 33.3, debate will be limited on this measure to no more than 2 hours. The time to be allocated at the discretion of the chair, and the chair allocates 1 hour to those proposing the bill and 1 hour to those opposing the bill. Representative McKillop.
Thank you, Mr. Speaker. May it please the ladies and gentlemen of the House. I bring before you the committee substitute to House Bill 954. I'd like to go through the bill first before we start addressing some of the issues that have been raised. First of all, in Section 1 of the bill, it makes legislative findings of this state consistent with legislative findings that have been made 7 years ago, that at 20 weeks after fertilization of a human ovum, there's a substantial evidence that an unborn child has the physical structures necessary to experience pain. There's substantial evidence that after 20 weeks after fertilization, unborn children seek to evade painful stimuli, that anesthesia is routinely administered to children of this age, that even before 20 weeks, unborn children have been observed to exhibit hormonal stress responses consistent with painful stimuli and the experiencing of pain, and that it is the purpose of this bill, the state of Georgia, and this body to assert a compelling state interest in protecting the lives of those unborn children at the point at which they can experience pain and to protect them from the pain of late-term abortions. Those are the legislative findings. We are amending the criminal abortion statute. It is already in law. That is, criminal abortion in this state is already a felony. It is already a felony that carries a term of 1 to 10 years. We are not changing that provision. It is found at lines 36 and 37 of the bill. The first changes are at 43 and 44, where we require a doctor to use using an objective standard of that doctor's performance to determine the age of the child in weeks from the date of fertilization. Down at lines 51, we determine that no abortion can be had if the probable gestational age of the child is 20 weeks or greater from fertilization. We have exceptions to that law for the life and health of the mother, as is defined at 56 and 57, and for the life of an unborn child, basically in the event of twins where one child has to be aborted to save the life of the other. You have to perform this abortion in a manner consistent with the best opportunity to save the life of the child. We have added Chapter 9B at line 88, which has the definition section. Abortion is already defined in our code in 31-9A2. Medical emergency, we have amended that definition later in the bill. Physician, probable gestational age, we have defined, and I will go over later why we're defining it the way we are. We ask that the physicians incur and use reasonable medical judgment, as said term is defined at lines 96 to 98. And it is required that for each abortion to be performed, that the gestational age of the child be determined. There is, in addition to that, a reporting requirement that is done in conjunction with the reporting requirements that we already have now in Section 31-9A6, which includes determining the gestational age, the method and manner of abortion, and whether or not there was a medical emergency. Section 4 is our redefinition of medical emergency, which is consistent with the rest of the code. Those are the changes to the criminal abortion statute that already exist. like to take a moment and we talk about why we're doing this. Why not just leave well enough alone? Georgia is second in the nation in late-term abortions. These are the barbaric procedures that are outlined in the booklet on your desks. I'm not going to go through them. The Supreme Court has identified them as gruesome, and I don't need to read them out for you. You can read them for yourselves. I feel it is the right thing to do to prohibit late-term abortions and to prevent pain-capable children from having to experience the pain of a late-term abortion. If this bill is passed and signed into law, we will be the 8th state to limit late-term abortions, the 7th state on account of pain. The fact is, Georgia has an interest in preventing human suffering, in preventing human pain, and preventing pain-capable babies from experiencing the pain of late-term abortions. In fact, it's not only a right that we have, it's a duty, and I'm going to go through where that duty comes from. We have been told by the Supreme Court of this nation that it is our job, that is the state's job, to articulate and find that it is the important constitutional role in defining our state's interests in the abortion debate. How did we get here to this point in the history of abortion? I'm going to do 3 minutes on what has happened. In Roe v. Wade in 1973, the seminal case, a court made up of 9 men found that there is a right to abortion and that the only thing that can infringe upon that right is when a state articulates a compelling interest in protecting some other right. That court found that there are 2 rights at interest and at odds: protecting women's health and protecting the potentiality of human life. Roe adopted a trimester framework that included viability as one of the markers, one of the benchmarks. Well, medical technology improved. 20 years later in Casey, that is Planned Parenthood of Southeastern Pennsylvania versus Casey, they discarded the trimester network. Justice Kennedy, and this is important because Justice Kennedy is seminal throughout these issues and these cases, he determined that regulation prior to viability, as long as it is not an undue burden on abortion rights, is allowable. It opened the door to articulating other valid state compelling interests in the abortion debate. That was in 1992. 8 years later in Stenberg versus Carhart, the majority of the Supreme Court struck down Nebraska's partial birth abortion ban. Justice Kennedy dissented, saying, Casey did not provide an exhaustive list of the compelling reasons. You are misreading Casey. It is a misapplication of Casey. Jump forward 7 years to Gonzales. Kennedy's assertion that there are additional state interests that can be articulated to promote life and promote the regulation of abortion prior to viability won a majority of the Supreme Court. That's 2007, only 5 years ago. Some of the compelling state interests articulated in Gonzales were protecting the reputation of the medical community, preserving the integrity and ethics of the medical profession, and promoting a societal respect for unborn life. The Supreme Court has not yet addressed the question of when in a pregnancy a state may regulate it to prevent fetal pain associated with abortion. That is what this law does. We will be the 8th state. Justice Ginsburg, in a dissent from Gonzales, said, "You are blurring the line that we have established as viability." And she was right. The line of viability is a horrible constitutional jurisprudential line. It changes depending on your physical location in the state or the country. It changes based on your race or your sex, your accessibility to excellent medical care. Viability is no standard at all, and we can do better. We have provided a different definition of gestational age. Many of the folks in the hall are talking about, well, we don't know anything before 20 weeks or 22 weeks or 18 weeks. And the fact of the matter is, we are defining gestational age as from the moment of fertilization. That is, our 20 weeks, when you look in that booklet, is actually 22 weeks. So if you look in that booklet at the 22-week-old baby, that is where we are drawing the line and saying that is a life. We believe that Georgia has a compelling state interest in protecting that life, and we need to do it. The other way of determining it is
20 weeks from the first day after the last cycle before the fertilization. That can be off by weeks and weeks. The way we have determined it, you can know to within a few days of when that life started and how old that life is. So when we say 20 weeks in this bill, it is 22 weeks the way many, many doctors, and when you're hearing in the hall, talk about it already. We have already made that move and compromise to those 22 weeks. The standard of care that you're hearing about in the halls, that is, when these tests are available, when we move the line from where it is now, a criminal abortion is right now at 26 weeks, the third trimester. When we move it to 20 weeks, the standard of care will simply move accordingly. That is, all of the tests that can be done at 16 weeks. All of the determinations to be made that you're going to hear about, I'm sure, at length from the other side, can be done at a stage where there's still plenty of time where we can respect the life of the unborn child and the other side's position on choice and 140 days of choice through those weeks. Now, I've been called a hypocrite during this process because while my bill seeks to end fetal pain associated with late-term abortion, it will not, in fact, end all fetal pain or suffering. Can I write a bill that will do away with every bit of fetal pain? No, I cannot. Every bit of human suffering or tragedy or misfortune or bad results? I cannot. Can I write a bill that will end shortened lives and loss and tears and grief? I cannot. But we wrote a bill that demonstrates this state's commitment to protecting life from the pain of late-term abortions. Not all abortions, barbaric late-term abortions. It does not include a loophole judgment provision. It does not include a provision for a godlike determination of what is a good life or a useful life or a futile life, for that matter. It just shows the respect for life and seeks to prevent human life from experiencing the pain of a late-term abortion, when all of the medicine and plenty of good studies show that babies at 20 weeks have all of the necessary physical parts to experience pain. Doctors aren't always right. They're not always right. When I was born, and I have a big question mark on whether I was going to tell this story, but there's a lot of misinformation going out in the halls. I had hyaline membrane syndrome. I lived the first week of my life with one lung non-functioning and only part of the other lung functioning, in a box with a tube in my head for food and a tube in my mouth for oxygen. My mom, when she woke up, because back then they put women out completely to have babies, saw my dad walk into the room and said, "How is he?" My dad said, "He's fine." My mom said, "You're lying." And for the next week, the pediatrician said, "Go home. It's in God's hands now." And I'm here to tell you, I stand here today to tell you that doctors aren't always right. If they'd had an ultrasound when I was 25 weeks in my mother's womb, they would have said I was incompatible with human life, that I would live a very short, very miserable 3 minutes, and I would die in my mother's arms. Well, doctors aren't always right. And so for every story, for every tragedy, there's someone on the other side who had a baby they loved, and who had a child that giggled, and who had a child that brought something to their family, and you don't compound a tragedy with another tragedy of aborting a baby when it can feel pain. This bill demonstrates this state's commitment to life. It does so reasonably, it does so accurately, it does so without loopholes, it does so in a way that it shows that our compelling state interest is in protecting life and making sure that we're doing it in a way that is meaningful, that is not just lip service to life. Mag put a letter on your table, on your desk. I'm going to go ahead and talk about it now. They have two concerns. One, that it is a crime. It's already a crime. They have a policy about objecting to any law that criminalizes anything that they do. And so their first sentence is already in the law as criminal abortion. It's at lines 36 and 37. It hasn't been changed. Their second concern is health of the patient. The health exception is already in there at line 57. where it deals with substantial and irreversible physical impairment. Both of their concerns are already met. Those are red herring arguments. The third argument that I've heard is that this law allows doctors who perform abortions to be identified. That is also inaccurate. If you go to line 110, it references that the reports to be done shall be made in conjunction with the reports required 31-9A6. If you actually go to that code section, 319A6 in the code, 319A6H says the Department of Public Health shall ensure that the names and identities of the physicians filing reports shall remain confidential. So the reports required by this bill dovetail into the women's right to know reports, which are already confidential under our code section. Now, in a little bit, I imagine that you're going to hear from Stacey Evans via video. I was given an opportunity to object to her being here today, and of course I would never object. She is a member of this body, and I respect her input, whether she can physically be here or not. I certainly congratulate her on the joy of life that she has experienced today, and I will respond a little more to that during the later portions of the presentation. I will stand for questions.
You have some questions. Do you yield?
Yes.
Chair recognizes Representative Abdul Salam to your right for a question. Not at her desk. Chair recognizes Representative Spencer to your right for a question.
Does the gentleman yield?
I do.
Isn't it not true in the original Hippocratic Oath states, I will give no deadly medicine, nor suggest any such counsel, and like any manner, I will not give a woman a pessary to produce abortion. Isn't it not true?
If the gentleman so states, that's my understanding.
Chair recognizes the minority leader to your left, Representative Abrams, for a question.
Will the gentleman yield?
Certainly.
You stated earlier that the state of Georgia is second in the nation. Can you list how many of these procedures are actually performed in the state of Georgia as compared to other states?
Past 20 weeks, approximately 12 to 1,500 per year.
12 to 1,500. How many?
According to the Department of Community Health, here's the count of abortions in Georgia, 20 to 40 weeks. 2003 was 568, 2004 was 615, 2007 was 637, and then we jump in 2008 to 1541, 2009, 1281 from the Department of Community Health. That's abortions past 20 weeks and later.
How many of those abortions are elective versus medically recommended or spontaneous?
My information is the great majority of those are elective because very, very few of them are the other kind.
And that's indicated on that information?
No, that's the other information that I have.
Can you tell me where the source of that information?
Other doctors and people that I've spoken to.
Can you list the people that you've spoken to or provide any other additional information? Because the information that you've provided from the Department of Community Health does not code by the type of abortion. It codes by whether or not it is or is not, but it does not provide information. So can you give us more empirical evidence beyond anecdotal conversations that you've had?
No.
Secondly, if you spoke to line 57 in the bill addressing the issue of physical impairment, can you give an example of what would constitute physical impairment, what's irreversible physical impairment versus something that would fall short of that?
Well, I'm not a doctor, but I would say an ectopic pregnancy would be something that would be in that category, uterine cancer, things of that nature that you have to ask a doctor. So
as the author of the legislation who seems to be pretending to be a doctor, my question would be if it's an ectopic pregnancy, the ectopic pregnancy, actually I apologize, sir, that was unfair.
I accept your apology.
As an ectopic pregnancy, how does that provide permanent physical impairment under the definition included in this language?
If it is a double ectopic pregnancy, it can destroy the woman's right or the woman's ability to reproduce and thereby substantially and irreversibly physically impair her ability to reproduce, which I would consider a major bodily function.
But if it's a single ectopic pregnancy, would they receive the same treatment?
I think that a single ectopic pregnancy can result, if allowed to proceed, in the tube exploding and a woman bleeding to death. So even a single would in my opinion, be a life-threatening occurrence that would require the termination of that pregnancy.
Can you give other examples of things that would fall under this safe harbor?
Uterine cancer is
So
another
there-
example. You'd have to ask a doctor. I don't pretend to be a doctor. I'm just giving you some examples of what would fall into the category very clearly for me.
Can you give examples of issues that would not fall into the safe harbor that you're trying to prevent? This is a fairly specific standard, and it seems to preclude certain activities that you would like to preclude. I'm trying to understand what those activities
I mean,
would
you
be.
know, we're talking about serious risk of substantial and irreversible physical impairment. Having a broken arm would not be a physical injury that would result in a serious risk of substantial and irreversible physical impairment of a major bodily function. That is not something that would therefore justify having an abortion.
Can you give some space between a broken arm and an ectopic pregnancy?
I'm
that
going
would
to
fall
leave
into
that to
safe
every member. I'll yield to another question.
Thank you. My final question is, you spoke to the issue of physical pain for a fetus in utero. Earlier when I'd asked this question in another committee hearing, there was not a response. Can you speak to whether or not you believe that it is possible for a fetus who develops, who has anencephaly or an unformed skull to feel pain as of the 28th week through gestation?
I believe that a fetus that has not developed all of the requisite physiological components necessary to experience pain, which would include all the pain receptors and nerves that lead from those to, at very least, the thalamus, cannot experience pain. I believe once you have achieved that level of development, which happens between 12 and 18 weeks generally, that is pain receptors, and during this time they are actually more pain receptors per square inch on a fetus than in any other time in our lives, and those pain receptors have nerve endings that run to the thalamus. That actually allows the fetus to feel pain, but not to have the requisite physiological capacity to damper that pain. So those babies actually have the worst pain.
So you would acknowledge that there are unborn fetuses who would feel pain, who would be precluded from being removed from that agony, even though they are almost certainly going to die upon birth.
And as I said, if I could write a bill that would eliminate all pain and all tragedy and all misfortune and all tears and all grief, I would write that bill. And I would sponsor it with you if you could write that bill. What I'm trying to do is end the pain associated with late-term abortions.
Is it not true, and this is my final question, is it not true that Georgia outlawed late-term abortions and we do not currently permit late-term abortions?
That is not true. There are such loopholes in our law that you can, even according to the Department of Community Health, we have abortions. In 2008, there were 2 abortions at the 40th week. So as someone is walking into a clinic in labor, someone had an abortion.
And going back to my original question, since you point that out, are you certain that that was an actual an elective abortion versus spontaneous?
I don't know of the 1,541 how many were spontaneous abortions or how many were any kind of other abortion, but I know there were 1,541.
Thank you.
You have other questions if you yield?
Yes, sir.
Chair recognizes Representative Smith to your left for a question.
Does the gentleman yield?
Yes.
Thank you. Prior to 1973, the passage of Roe v. Wade, were abortions being done in the United States of America?
I'm sure they were. I don't know that, but I would surmise.
So after Roe v. Wade has been passed, and where we are now in the state of Georgia, this austere body, we as conservatives, this entire body has been in the midst of shrinking government, have we not?
Since 1973?
Since we have been in session this year.
Well, I think our economy has expanded during that period of time. I'm not sure exactly what you mean. We're doing our best to shrink government with the red tape watch.
Very good. With respect to shrinking government, if we were to pass this legislation, would we not have to create another legal arm for law enforcement to enforce in order to catch doctors that are courageously seeking to help women do what men cannot do?
No, sir, I respectfully disagree. We've already got criminal abortion in the state of Georgia. We're merely using what the Supreme Court has given us and articulating a compelling state interest to determine exactly when the line has to be drawn. The Supreme Court in '73 admitted, Justice Blackmun admitted, this is an arbitrary line. You have to draw it and then articulate a reason why it is the important line. We already have criminal abortion in this state. It's 26 weeks. What we're doing is setting a bright line test consistent with the law that we passed 7 years ago in the Women's Right to Know Act, saying that babies can feel pain at 20 weeks, and that is where we should cut off late-term abortions.
Is it not true that during the roaring 30s when we had prohibition, there were millionaires made because of illicit sales of alcohol?
I wasn't there.
Well, in line with what you just said with you not being here, you're here now, but perhaps all of you are not here. So, in the state of Georgia, has any man ever had a baby through natural childbirth, through artificial insemination, or through immaculate conception?
No.
So with that being said, with us not having the proper machinery to actually have babies or know what it feels like to go through what you just said, and in light with the fact that what you just said, and I empathize with the fact that you did have a medical problem when you were born, probably the medical technology was not such to the point where they could have diagnosed whether you needed to come or go. Would you agree with that?
No, I agree with that completely.
I have no further questions.
Do you continue to yield?
Yes, sir.
Chair recognizes the chairman of the Insurance Committee to your left, Chairman Smith, for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes.
Got a hypothetical for you. Let's say you find out that the child is does not have a kidney. Some cases may not have a brain, and a number of other defects that can occur. I know I lost a grandchild because didn't have kidneys were not functioning properly. What do you do then? Do you make the mother carry the child through pregnancy, or how do you handle that?
What I think is going to happen is that the standard of care to determine those issues that can be determined, and they can be determined now, will occur at 16 weeks according to the standard of care that we have now. They don't happen until sometimes 18, sometimes 20 weeks. But when the standard of care is moved, pursuant to our enacting this law, it will be 16 weeks. People will be able to know earlier when you have the conditions that you're describing.
Isn't it true that I just got off the phone with a very good friend of mine who's an OBGYN, and he said you may not know some of this by the time they're 20 weeks, and the OBGYNs that I've talked to are adamantly opposed to this bill.
And I think that the answer there is, when you use that kind of example, you may not know this until the 38th week, and I don't think anyone would agree that you could abort a child at the 38th week. It's a matter of life, and that's what we're articulating, a compelling state interest in protecting the life of unborn pre-viable fetuses from pain at 20 weeks. Mr. Speaker, I'm going to leave enough time for any others who want to speak on the bill. I yield the well.
You have other questions if you choose to yield. Chair recognizes Chairman Cooper to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I hadn't planned to come to the well today. I was spending the day thinking how I was going to vote on this bill because I had serious problems with one issue until I checked another aspect of the bill and found that I had been misled on a very important issue. My two areas of issue were on problems of complicated pregnancy when there were fetuses that were incompatible of life. It's like Representative Smith talked about. I think I'm probably the only person in this room, except people like Representative Smith and 2 or 3 other representatives that I know personally, that are too emotional to come and speak to you, one on the Democrat side and one on the Republican side, who have just gone through having family members or themselves losing children with problems that were incompatible with life and the emotional trauma that wrought on their families. But I think I'm the only one because I even asked Representative Watson. He has not seen an can't even say it. He has not seen a child without a brain. I have. I taught OB. I had students there. A baby was born. From the front, it looked just like a regular pretty little baby. But when you turn the head around, it looked like somebody had sliced the back of the head off, and hanging from a little sack was what was supposed to be the brain. That's incompatible with life. And making a mother carry that child to term is cruel and inhumane punishment. Think about when that mother, if they happen to miss this cutoff, goes to the grocery store and she's 7 or 8 months pregnant and somebody says, "Oh, you're pregnant. Is it a boy or is it a girl? I bet you're so excited." Or when they go to church or to the beauty shop. I've seen the child born without lungs. As it gasped and its little chest was contracting, trying to breathe, as it died right after delivery. Do you know what it's like? Mothers are awake in the delivery room nowadays. So I had that problem with this bill. But I was going to try to eat that and vote that way until, returning from talking to somebody else in the hall about a totally another issue, I was threatened by a person from the Georgia Right to Life. And I want to tell you, I was sent down here by my constituents to vote my conscience. And that is the first time in 16 years that I have ever been threatened. Now, I was called stupid one time by a trial lawyer who couldn't convince me to vote his way and finally said, "You're just too stupid to understand the situation." And my school teacher came out and I, with his finger, went, "Oh, no, 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 no. You're the one that's stupid because I get to go in there and vote green or red against you from now on." But I've never been threatened. And I don't think the citizens of my district would appreciate the fact that somebody who doesn't live in my district was threatening me. My vote's not for sale, and it is not to be threatened. And that's why I decided to come down here. But the other problem I have with this bill is that, well, several. Much of what the representative has presented to you has not been on good scientific data. He gave and showed me the email from a physician in Athens who's considered to be a physician on the fringe by the other OBGYNs, who he says has no dog in this fight, so he's right, and he is basing what he says on that. Well, this is from the American College of Obstetrics and Gynecologists, 2009. It was reaffirmed in 2011. Fetal anatomy, as described in this document, may be assessed adequately by ultrasound after approximately 18 weeks of gestation. And it's looking for the things that we're talking about, and that is, it can be, assessed, and it's estimated. It's not, medicine is not a science. It's an art. And you can't always tell exactly the age of a fetus and what's going on. And at 18 and 20 weeks, there are still parts of that little fetus's body developing. And when they talk about pain, I was here. I negotiated the woman's right to know. It came out of my committee. And at that time, we had that one 18-year-old study about fetal pain. Well, medicine's come a long way since 2005, and we have later studies done by the Royal College in England and by one of our best academic things that say it's really 23 to 29 weeks when those little fibers can go to the correct part of the brain and that they may feel fetal pain. So research is developing, and I feel like a lot of what you've been presented has been based on faulty information and hearsay. But worst of all, Georgia is 48th in the number of physicians per 100,000 to take care of just regular patients. And we are extremely short on OBs. Now, if you want to put it up on the thing, I gave y'all yesterday something that was done earlier, because I want more residency slots for OBs. I want us to pay them more so that we can get them, especially in the rural areas. But I want to put it up for here, and you look for your counties. I think the speaker lives in Gilmer. I'm not sure quite. There's no OBs in Gilmer County. And the counties around them are short, are in danger of losing their physicians. In 2004, there were 13.5 OBs per 100,000 residents in the state, 13.5. In 2008, it was 10.9. Our OBGYNs, just to deliver regular babies, are decreasing, and many of them are in their late 50s. And they're retiring, and we're not getting them to come back to Georgia. We are in desperate straits just to get OBGYNs to take care of women and regular pregnancies. 2 years ago, we had this bill up, and I went to the committee. Somebody said, well, why aren't you going to the committees this time? I'm not going this time because last time, being straightforward, just like I am, I objected to the fact that it was in Judiciary Non-Civil, and there was a subcommittee one night, and it was put on the full committee the next morning. We never do that in Judiciary, and I objected to that, and I said, this puts my regular docs in danger, and I'm not going to vote for something that puts my regular doctors trying to help women have babies in this state in danger. And members of my own party used that against me in my last election and tried to get the picture of me, because I was pretty hot that day, to use against me. One of the reasons I hadn't gone this time, and because I've tried to work behind the scenes and talk to the author of the bill and other people, and I had been assured by the chairman of the committee and by the author that this time my doctors were protected. And I was sitting there trying to decide about the bill. And then I decided to check it. Something happened, and I decided to check it. 3 lawyers, one a lobbyist, one a respected member of this body and our Republican Party, and another respected lawyer that works in this House that doesn't want to get involved, and I'll tell you why in a minute, have confirmed the way this is written in here, regular doctors are not protected, but they have to report if, they do one. I don't want my regular OBGYNs and my OBGYN specialists who are just trying to do the best job they can do, having their names made available to the public so that the crazies can do what they have done to a doctor who is a doctor in one of our major hospitals in this city. There he is up to 25 threats against his life or his business, to the point that his hospital would not let him come down and testify. And that is all he did. 2 years ago, he came down and testified, and apparently in the Senate, and apparently was so effective that they didn't want him to come again. So his life and his business has been threatened. That is not right. We ought to be able to let anybody come testify so that we get both sides of the issue. If you are an abortionist and you choose to be an abortionist, I don't see how anybody does that. I'm pro-life. Not according to Georgia's pro-life, because I believe in the exceptions. But I'm pro-life. And I don't see how anybody makes a living just doing abortions. But right now, they're legal in the United States, and as long as they're legal and doing, I don't want them killed. But I don't want my regular physicians, where we have so few. There are only 6 OB specialists, perinatologists, south of Macon. And if this bill passes, wealthy women will be told to go to New York. It won't decrease the number of abortions. The doctors, because they're scared, will not do it here, but they'll tell them to go to New York. But for middle class women who don't have a lot of extra money in this kind of economy, and poor women who often cannot even get in to see a regular OB till the 19th or 20th month in South Georgia and all up in the mountains for their first visit just because they can't afford it or the obstetrician is so busy, that's the first appointment they can get. They will have to deal with those problems and carry those problems to term and suffer with them. So I would ask you, I don't understand why we could not make adjustments to this bill and they would not accept any. And all I have been asking for is that at least be recommitted to rules and we clear up that one issue at least to make sure not the abortionists that do it for a regular living and elective abortions, but the ones that are just trying to practice their profession and help women and deal with really bad pregnancies with bad outcomes, be not put at risk of having their names out so that they can be harassed and threatened. That is all I am asking, and there's plenty of time for that to happen. If that happened, as much as I would hate to do it for the late term, I could feel like I could vote for this bill. Thank you, Mr. Speaker. I've had my say, and I yield the well.
Lady has yielded the well. I don't really care which side you are on this issue, but there will not be outbursts like that again. Regardless of the position that the member takes in the well, that doesn't accord the dignity that this House ought to show. Chair recognizes Representative Kaiser to speak to the bill. Representative Kaiser.
Thank you, Mr. Speaker. I rise today because I'm pro-life. I'm also pro-choice. I'm also the mother of two gorgeous, wonderful boys, Willem and Ewan, 13 months apart. And this is a disturbing time to come to the well for me because I took pause at a story that I heard recently. Actually, I didn't take pause. I read it in horror, and I thought I should come to the well and share it with you. I'm just trying to remember both of my pregnancies, the joy I had when people came and said, "Do you know the sex of the baby?" And I remember working on the nursery, and I remember my twin sister painting the nursery, and I try to imagine if I were in the shoes of the woman whose story I'm about to share with you, what it would be like if this bill passes and she were unable to make the choice that her family had to make. How it would be for her to have people approach her and say the things that they said to me when I was in such a joyful time. So today I want to share with you Anna's story. In 2007, Anna and her husband decided to start a family. They were thrilled when they became pregnant. Anna says those few months were the happiest of her life. They knew they were having a boy and they couldn't wait to have their anatomy ultrasound at 19 weeks to see the images of him. At the anatomy scan, they found out there was no amniotic fluid and the baby was hard to see. The doctors told them there was no amniotic fluid because their son had bilateral renal agenesis, meaning the kidneys had never developed. He was also missing his stomach and bladder. Amniotic fluid is necessary for the development of the baby's lungs, and the absence of it leads to a constellation of physical features known as Potter's syndrome. Because Anna's baby was not cushioned by amniotic fluid, her organs pressed on the baby, causing physical deformities, including abnormal limb growth and flattened facial features. Anna's baby had a fatal condition. If her son was to even survive the rest of the pregnancy, they were told he would die of respiratory failure as soon as he was born. Anna described the pain, the trauma, and the overwhelming sadness that she and her husband felt. They had spent years preparing for a family and months bonding with this baby. They wondered if he would be musically talented like his dad or interested in
interested in science, like Anna. They had planned his nursery. They were going to decorate it with a jungle theme and buy their son dinosaur pajamas. Anna said there are no words to describe the heartbreak that occurs when you switch from planning for your baby's future to the reality that he cannot live. Anna and her husband had to make decisions. She and her husband weighed their options carefully. She considered continuing the pregnancy, but could not imagine how she could ever leave the house or face anyone knowing that her baby was going to die. She was scared to answer innocent questions about her pregnancy without breaking down. And she knew, health-wise, it was safer for her to terminate the pregnancy. Anna's husband stopped touching her stomach, trying to distance himself from this son, and trying to ignore his grief. Their deciding moment to terminate the pregnancy was when they realized that they didn't want their son's life to be spent in an environment that was so cramped that the body grew deformed and he couldn't move around, only to suffocate upon birth. Their son was not going to live regardless of when he was born, and as his parents, they felt compelled to consider the quality of his short life. This is Anna's message to the House of Representatives today, in her own words. Legislation restricting all pregnancy terminations after 20 weeks gestation, except when the mother's life is in danger, ignores the families where a fetus tragically receives an adverse prenatal diagnosis. Many serious, most serious conditions are discovered at the anatomy ultrasound, which happens around 20 weeks gestation, and it can take several weeks to get further testing, so it is not usual for women to pass the 20-week mark before a final diagnosis is made. And importantly, some time is needed to make an informed decision regarding continuing or terminating the pregnancy. Carrying to term is not in the best interest of all women and their families for a variety of physical and mental health reasons. Additionally, carrying to term can mean that the fetus suffers for a longer period of time and has a more traumatic death. I ask you that you listen to Anna's story today. Consider what Anna and her husband went through. Consider their devastation. Ask yourself if you could look Anna in the eye and say, I've decided that you must carry that baby to term and live pregnant for the next 4 to 5 months, knowing he will die. That's what a yes vote on 954 says. A yes vote says, I don't trust you to make the best decision for your family. Hear Anna's story. Vote no on House Bill 954. Mr. Speaker, Representative Stacey Evans could not be here today. She wanted to be here, but we all know for the joyful reasons why she couldn't be here. Her birth of her first child, a baby girl. She was recorded her testimony, and I hope that you will pay close attention and watch it now. Thank you, Mr. Speaker.
The chair has indicated to the minority leader of the House that I will allow Representative Evans to speak via the recording. This will not be considered by the chair as a precedent for future situations. I'm doing it to be fair to all sides in this debate and due to the unique circumstances of the representative. But I will not have it considered to be precedent for future such request.
Good morning, ladies and gentlemen, or afternoon. I'm not really sure which it is yet. As most of y'all know, I'm not there in person today. I am actually down the street at Emory Midtown University Hospital, or Crawford Long, as many of y'all know it, having a baby, or maybe I've even already had a baby. Y'all should know by now, hopefully. Hopefully I know. And I hate that I can't be there with you in person, but I didn't want to be left out of this discussion because I think it's a really important discussion that we're having here today. And I thought, given that I am literally delivering a baby today, I'm someone who is very familiar with some of the steps that are being discussed today, and somebody who's gone through all that process very recently. And I know there's been a lot of talk about when tests for fetal anomalies can take place and when they do take place. And I just wanted to tell you my experience. I had many of the tests to test for fetal anomalies around 20 to 21 weeks. And when you have those tests, you go into your doctor's office and you have your test. You have blood work done, give samples, all sorts of all sorts of things, and then those samples are taken and tested, and then they come back to you, and that alone takes time. It was usually about a week before I would find out how those initial tests went, but that wasn't the end. You know, fortunately for me and my husband, everything came back from those initial tests normal, and we didn't need to go any further. But if those levels had tested, if my levels had tested abnormally, there would have been another test, and then there would have been another waiting period. So for me, when I started, let's say even the earliest test that I took, starting at 20 weeks, we're not talking about a decision, we're not talking about me having the results immediately. We're not even talking about me having the results a week later. We're talking about most likely 2 or maybe even 3 weeks later. And again, very fortunately, my husband and I didn't have anything come back abnormal. We didn't have to make a difficult decision about what to do if we were faced with knowing that our child might not make it very long outside of the womb or would have a very challenging life with complications that I don't even want to imagine right now. We didn't have to make those choices, but so many women do. And that is their choice. That is their choice with their husband and their God and their doctor. And I can't imagine being those women and having gone through the process and followed my doctor's advice and taken the tests when I was told to take the tests, and then being told that being able to make a decision based on those tests was ripped away from me by this General Assembly. And not only that decision was ripped away from me, but then that I would be forced to carry a child to term that I knew was not going to be able to live outside the womb. And having been here in this house for the last several weeks has been pretty amazing for me. Y'all have been, the family atmosphere that exists under the dome has really come to light. Every day, you come by my desk and you ask me, how are you doing? How is the baby? How's the nursery coming along? Is it a girl? Is it a boy? I can't even, and you can tell I'm tearing up a little bit here, I can't even imagine having to answer those questions, knowing that I was carrying a child that may not live outside of my hospital stay. And as much as I know that y'all care about me and care about the women of Georgia, the decision about what to do if I were faced with that terrible situation would be mine. Again, it would be mine, my husband's, my God's, and my doctor's. And as much as you care about me, you would not be in that doctor's office with me when I was faced with that very difficult situation. And none of us in here are going to be with the millions of women, hundreds, thousands, however many there are, that would be faced with these difficult decisions. As much as I know you care about Georgia, I do too. Those are the decisions for our daughters, for our sisters, for our aunts, for our friends. They're not ours. Trust the women of Georgia. These are incredibly difficult decisions that I'm so thankful that I haven't had to make, but I know that many of my sisters in the state have had to and will have to. And again, it's their decision. It's not ours. You would trust me to make the decision, I believe, and we should trust every woman of Georgia and her family and her God and her doctor to decide what to do in this difficult situation. It's not our decision. Thank you for letting me speak to you by video, and I'll see y'all soon. Good morning.
Chair recognizes Representative Ash to speak on the bill.
Thank you, Madam Speaker. Today I share with you Jane's story. I'm calling this girl in this real life story Jane because she was only 14 years old when this happened to her. I want to protect her identity. Since Jane was in elementary school, she'd been molested by a family member, a respected leader in her family's church. He molested her for years. And for years, this family member threatened to kill Jane's brother and her mother if she told. At 14, Jane realized she was pregnant. She was terrified because she knew that people would find this horrible secret out. She was terrified because she believed the man molesting her would kill her mother and her brother. As time went by, this victim of horrific crime was having to deal with a situation that no child should ever have to endure. Jane's desperation continued to grow. She continued to be victimized, and the man responsible continued to threaten to kill family members if she told. Finally, in growing desperation, she found a weapon. She barricaded herself in a small room and threatened to kill herself. Fortunately, Jane's mother and soon thereafter the police became involved. Her mom and law enforcement were able to reassure her that she was now safe. Jane's mom contacted a clinic here in Georgia to learn about options. She told the clinic that Jane's rapist was finally in jail, and the prosecutors would need DNA samples after the procedure to prosecute him for his crime. Jane's mother called clinics in 3 other states and was told that they would not help them. Georgia was their last option. Jane came to Atlanta from a bordering state more than 20 weeks pregnant. Escorted by her mother and a sympathetic law enforcement officer, Jane was able to obtain an abortion here in Atlanta, performed by licensed and trained medical doctors who had the expertise to treat patients in these extreme and painful situations. I ask that you listen to Jane's story. Consider what she and her family went through. Think about the trauma a little girl had to endure at the hands of an incestuous rapist. Ask yourself, if you could look Jane and her mother in the eye and say to them, I believe Jane should be forced to carry a baby conceived in incest to term. I don't believe that victims of rape or incest deserve a choice. That's what a yes vote on 954 says. A yes vote says victims of horrendous crime, girls raped by their family members, should not have a choice. Had this bill not been structured today, I would have offered an amendment to exempt victims of horrific crime, victims of rape and incest, from these arbitrary time limits. Let's table the bill today and work on these problems. If this bill is not sent back to committee, then I ask you, hear Jane's story and vote no on House Bill 954. Thank you, Madam Speaker.
The lady has yielded the well. The chair recognizes Representative Bell to speak on the bill.
Thank you, Madam Leader. When I was 27 years old, I had a procedure to have fibroids removed. Fibroids are a serious condition experienced by many women that is painful and is dangerous. One of the main side effects is bleeding uncontrollably for weeks and even months. That side effect leads to a host of illnesses, including extreme anemia, and as a result, I had the fibroids removed. 1 year later, I was informed that the fibroids were back, and more so, they were enlarged and causing a strain on my uterus. After a year of tests, procedures, medicines, poking, and probing, I was diagnosed with critical anemia. In essence, my blood levels were incompatible with life. I was faced with having to make an extremely hard decision: have a hysterectomy or take the risk of dying. Now, to some, that might not seem like such a hard decision. The exception was that I have always wanted to give birth. I always knew I would be a mother. I was being told that due to a severe medical condition, my dream would no longer be a reality. My first thought was to continue with the treatments, have another procedure, and try to conceive a child. Unfortunately, I was told that should I choose that route, I would indeed jeopardize the life of my child and my own life. My situation was just that dire. After counsel with my partner Valerie, several doctors, my pastor, and my parents, we made the most difficult medical decision to go forth with the hysterectomy. For the next 2 years, I mourned the child that I never conceived, always wanted, and whom I greatly miss today. My emotional health was hanging by a string. Even my spiritual health was at risk. However, I am thankful that I had doctors who were able to help me and my family make the medical decision that was best for us. Emotional stress and post-traumatic disorders are real. They are medical conditions that all of us stand to grapple with from time to time. Should I have chosen to conceive, it is very likely that my medical emergency would have forced me to terminate my pregnancy under 924, and my decision would be criminal. Jennifer Peterson was 35 and pregnant when she discovered a lump in her breast. Tests showed that she had invasive breast cancer. The cancer and its treatment, separate and apart from the pregnancy, were a threat to her health. A strong medical emergency exception recognizes that added threat to her health posed by pregnancy during the onset and treatment of her cancer. HB 954 does not have a strong medical emergency exception and would force Jennifer to continue her dangerous pregnancy. About 1 in 3,000 pregnant women get breast cancer during their pregnancies. And for these women, a comprehensive medical emergency exception, one that allows actual medical doctors to use the discretion they were trained for, is absolutely necessary. The language in the medical emergency exception is insufficient to protect women's physical and mental health and removes the ability for a physician to practice emergency medicine as they are trained. Had this bill not been structured, I would have offered an amendment that would have continued to allow trained medical doctors to provide a medical emergency determination that is, in his or her best medical judgment, best for the patient. This bill is a misnomer. It is not an abortion bill. It is a criminalization of warranted medical decision-making. We have been given a pamphlet, Abortion, A Woman's Right to Know. While it shows the development of a healthy fetus through 40 weeks, it fails to show the great possibility of a fetus with an undeveloped heart, no heartbeat, undeveloped brain, major congenital anomalies, or like Jennifer, a mother's medical condition that would not allow the fetus to survive outside of the womb. Oh, that we would give the same level of care and concern to the medical condition of women and their families as we give to outdated misinformation on the condition of a fetus. I would offer to the author of the bill that his family had a choice. Don't take that choice away from other women in Georgia. Let's table this bill and work on these problems. And if it's not sent back to committee, then I ask you to hear my story, to hear Jennifer's story, to vote no on HB 954. Madam Speaker, with my heart laid bare before this House chamber, I yield the well.
The lady has yielded the well. The chair recognizes Representative Holcomb to speak on the bill.
Thank you, Madam Speaker. I begin by saying that doctors may not always be right, but politicians sure as heck aren't always right either. I'll also say to the gentle lady from Marietta that there are other members in this House who have been impacted by this. I want to begin by acknowledging that this is an extremely difficult issue. I respect those who, because of faith and principle, are pro-life. I really do. I do not respect those who use this issue for politics or for a contested primary. I struggle with this issue more than any other, but I can't support this bill. I know about high-risk pregnancies. I know that a woman can experience a high-risk pregnancy because of age, family history, and other factors. If a woman has a high-risk pregnancy, she can undergo a procedure called amniocentesis. Amniocentesis is a medical procedure used in prenatal diagnosis of chromosomal abnormalities, and it involves a needle being inserted into the mother to retrieve a small amount of amniotic fluid. It's not a pleasant experience for the mother, and it usually occurs between 15 and 20 weeks. When the mother receives the results, which could occur just before, right at, or following 20 weeks, she could learn that her baby has severe birth defects and may not survive the pregnancy or birth. This decision for the mother is incredibly difficult. She either continues the pregnancy and will undoubtedly be asked about her pregnancy time and time again, knowing that her pregnancy will not end well, or she discontinues the pregnancy. This is an agonizing, painful, and heartbreaking decision. Believe me when I tell you this. But it is a decision that has to be made. And it should be the mother, not us, who decides. Because the decision is so difficult, so personal, I cannot approve this bill. To do so would be to decide for a mother. I can't do that, and I believe that if our state were to enact this into law, it would be intolerably cruel to Georgia's mothers. Intolerably cruel. As a man, I don't think I or this House should make the hardest decision any mother could ever face. That's why my vote today is pro-mother, and I will vote no. I yield the well.
The gentleman has yielded the well. The chair recognizes Representative Parent to speak on the bill.
Thank you, Madam Speaker. I rise in opposition to HB 954. I have a very close friend who indeed was one of those mothers, and her husband was one of those fathers that only 3 short years ago faced the unthinkable, the horrible situations that we are hearing about today during her pregnancy. And all of us walked through that horrible experience with them. And I still get very, very emotional even remembering it. So I'm going to tell you a little bit about what happened to them. This dear friend of mine was in the terrible position that all women who are pregnant live in fear of. And I've been pregnant, and I have a son that just turned 2, and he's perfect and adorable. But when I was pregnant, every time you get those tests, you're scared at what you might find out. Every woman in here who's been pregnant, everyone who's a father, probably to this almost the same extent, knows of the emotion of which I'm speaking, that you're nervous that you might get bad news. Well, that did happen to this dear friend of mine. And at her 20-week ultrasound, she was told that there had been a blockage in her baby boy's urethra that prevented his son's lungs from developing properly. And she and her husband were obviously devastated. Their doctor explained that they could attempt a surgery that might be able to fix the problem, and that as the pregnancy continued after that surgery, perhaps there would be some hope that the child would develop more normally and be able to live. The procedure went fine, but a few weeks later, around 25 weeks, their doctor did deliver the final horrifying news that too much damage had been done. Their son's lungs would not develop normally, and upon his birth, he would certainly die. Her baby lived for about 1.5 hours when he was born, and his name was Mac, and he was in distress that entire time because he could not breathe. And she did not know this. She did not know that that was what they were going to be facing until the 20-week ultrasound. And even then, she was given options to see if the pregnancy could be salvaged, if there would be an opportunity for her son to live. And I'm so glad that she was able to take that time to see if something could be done to save her son. And in the end, he couldn't be saved, but at least she was able to try. And they weren't under an arbitrary deadline and arbitrary pressure that might make them make a decision too quickly without full information. Colleagues, it is not all right for the state to tell a woman and her family, when she is facing probably the worst news of her entire life, that she is forced to carry a child that will die to term. It is a horrific position to be in, and it is something that none of us can have any idea how we would handle unless we ourselves have experienced it. It is gut-wrenching to be pregnant and hearing well-meaning questions every day when people congratulate you, when they ask you when you are due, when they ask you whether your baby is a boy or a girl. It is a constant reminder to the mother that her hoped for and dreamed about child will die. It is destroying to feel your baby move inside you and know that as soon as he or she is separated from your body, that movement will stop forever. And it is for that woman and her family in that situation to decide whether they are emotionally, physically, and psychologically capable of continuing a futile pregnancy. It is just not okay. It is not okay for the state to force a woman to carry a child that will die. It's not okay. And with that, I would like to request that all of my colleagues vote no on this ill-advised legislation for my friend and the thousands of other women who have been in that unspeakable situation. Thank you, Mr. Speaker. I yield the well.
Lady has yielded the well. The chair recognizes Representative Neal of the 75th to speak on the bill.
Thank you, Mr. Speaker. I actually had a completely different speech I was going to give, but I felt it necessary for me to give a more personal story. As a detective, I worked a rape case for a teenage girl She was brutally raped, and her father was completely against abortions. So when it came to time that it was advised that she needed to have an abortion so that we can have the fetus to do a DNA sample. Her dad, that did not sit with her father. And as detective, we give out information. So the father had my phone number, and I tell you, it took weeks. He called me every single day, almost crying, because he was stuck between letting his daughter have a child of a rapist versus going against everything that he believed in for over 50 years, not being a supporter of abortions. And essentially, they ended up getting the abortion, but like I said, for weeks, that man called me every morning before he went to work, trying to, pray and work through a decision to decide if he was going to let his daughter have this abortion or not. So after the abortion was done, I did have to go up and I had to get a fetus. I had to get the fetus, the result of something that was so negative and so morbid that happened to a teenage girl. But with that, we went ahead to prosecution and what have you. But I did want to just cut my comments short and give you that personal situation to let people understand that people's situations are different. You don't know what people go through, especially rape victims. I sincerely hope that none of you have to make that decision yourselves, even people that are completely against abortions. But even with this family, they had to go through something this bad, and as I demonstrated, sometimes women and even men, and the father in this case, who was completely against abortion for all his years of living, needed to have the choice to save his daughter's life and maintain his dignity and not give life to such a brutal crime that essentially killed his daughter emotionally on the day that it happened. Thank you so much, and I yield the will.
Lady has yielded the well. The last speaker against the bill prior to the minority report, Chair recognizes Representative Hughley to speak on the bill. There are 14 minutes left.
Thank you, Madam Pro Tem. Ladies and gentlemen of the House, I come today very troubled because I come today with a mother's heart. And my husband always complains that even though I only gave birth to one child, I continually bring home other children for him to take care of because I have a mother's heart. And I'm saddened today that I'm standing here talking about this situation because we all know what this is about. But let me just tell you that it's been said that bad facts make bad law, and bad laws have unintended consequences. So I stand before you today to bring a story from a Georgian. Her name is Vicky Stella. She's a diabetic, and she discovered during her 22nd week of pregnancy that the fetus she was carrying suffered from major abnormalities and had no chance of survival. Because of Vicky's diabetes, her doctor determined that induced labor and cesarean section were both riskier procedures for Vicky than having an abortion. The procedure not only protected Vicky from immediate medical risks, but also ensured that she would be able to have children in the future. HB 954, as written, would not allow a doctor to perform the procedure that is best for the patient, like in Vicky's case. Instead, a doctor must perform the procedure that gives the fetus the best chance of survival outside of the womb. And in nearly all cases, this would be a cesarean section. And I gotta tell you, I was shocked when the doctors that we talked to told me that this would mean having a cesarean the old-fashioned way, when women of my era were cut straight up the middle and filleted open like a hog to deliver. Cesarean sections are invasive and serious surgeries. The stomach muscles are sliced through, recovery time is longer, and the procedure has been thought to have precluded women from experiencing healthy vaginal deliveries in the future. Government, in this case, is going too far by mandating that physicians provide patient care that may not be medically accurate, that may not be best practice or safest for the patient. Had this bill not been structured, I'm old enough to have been here in the old days when we could actually make amendments to bills. And had this bill not been structured, I would have offered an amendment that would have continued to allow trained medical doctors to provide the care that in his or her best medical judgment is best for the patient. As I said in the beginning, bad facts make bad laws with unintended consequences. I ask you to let's table this bill and work on the problems that it presents. And if it's not sent back to committee, then I ask you to do the only wise and just thing. I ask you to hear Vicky's story and vote no on House Bill 954. Thank you, Madam Speaker, and I yield the well.
Lady has yielded the well. The chair recognizes Representative Taylor to speak on the bill.
Thank you, Madam Speaker. Members of the General Assembly, I stand before you today to address House Bill 954. There are many ways to look at this legislation and just as many opinions. The matter of abortion is not something new. I wanted to share the story of two women. It goes back to the 1950s. There was a young mother with a 1-year-old child. Well, she had just left her husband, which was a big deal at that time, and she was getting a divorce. Guess what? She discovered she was pregnant again. She was young, she was naive. Times were a lot different then. She was not very worldly. She didn't have all of the resources that we have in today's world. Well, she went back to her husband and she made the decision to deliver a healthy baby, and she did. After that short postponement, she did divorce her husband. The birth of her second child did temporarily interrupt her life. Now let's jump ahead to 1974 and meet another young woman. This is another young mother. Times were different. The country is in the middle of the Great Recession. High inflation, long gas lines, job layoffs, difficulties everywhere. She discovered she was pregnant. Now, she is a happily married young woman. Just 5 months earlier, with some health issues, she had just delivered a baby. And now she was pregnant again? Wow, what a shock. What was the first thing that she faced? Her doctor. He assumed and actually recommended she have an abortion. It came as quite a shock to her. She knew there was a new law out there, but how and why would that affect her? Well, even with her ongoing health issues, she went on to deliver a healthy baby. That baby had actually planned to be here today, for you see, it's my 38-year-old son. He couldn't be here today because his 6-year-old son has a virus. Joey was unable, but I wanted to share the rest of this story. I can't begin to tell you because there is no way to ever fill the void if that child had not come into this world. Why my doctor wanted to recommend an abortion, to this day, I will never understand. But what does this story have to do with today's bill? The words my doctor spoke to me 38 years ago have never left me. Words have meanings. Have you ever said something and wished you could take it back, but you can't? The words are out there hanging in the air. They can't be erased or whited out or deleted. You can apologize and try to make amends, but the damage is done. You choose to use those words. Speaking of words, have you ever heard an expectant mother say, "Oh, I'm so happy I'm going to have a fetus"? Words. Well, in the case of abortion, words have been used to try to define when a life is a life. At what point is a baby a baby? I will not try to define that today. Again, there are as many opinions as there are people to speak them. But one fact is known. Long before 20 weeks, this living being, this baby, who with its own individual genetic code and DNA is a human being. It's alive, living in the womb. This child is affected by pain. It feels pain, the same as you and I. Now let me get this straight. We can't spank a 3-year-old without answering to DFACS, but we can inflict the ultimate pain to a baby in the womb. Something isn't right. I ask each person in this assembly to search their conscience and search for words that would allow this travesty to stop. Today, at this moment, the word is yes. Please vote yes to House Bill 954. With that, I yield the well.
The lady has yielded the well. The chair recognizes Representative Hamilton to speak on the bill.
Thank you, Madam Speaker. Seems like I've been at the well a lot recently. And I want you to know that everything I say today, really haven't thought about it a whole lot. I've prayed about it. I've gone to a lobbyist friend in the halls, asked him to pray for me that God would give me the right words to say here, and I certainly hope that that's what I'm able to do. First thing I want to do is I want to thank leadership. I appreciate Speaker Ralston. I appreciate the leadership of this great body, and I appreciate their courage for allowing us to move on a bill that we have the opportunity to take a stand on. This is not Illinois. We don't get to vote present. We will find out today whether you support sanctity of life or whether you choose to not support sanctity of life. It's really that simple to me. Let me tell you a little bit about myself, not that you care. I'm a product of a wonderful childhood. My parents just celebrated last year their 65th wedding anniversary. Had a great childhood, have great memories. But a lot of values were instilled upon me, and this is not a value judgment, but I was taught a lot of things. I'm married. I have 3 wonderful daughters. So I can assure you the discussion of abortion, sanctity of life has come up in my home many, many times. I served on a board of directors of a crisis pregnancy center in our community a number of years ago, long before I got involved in politics. I was very excited in early years as a legislator that several years ago, that we were able to pass the sonogram bill. And basically the reason I was excited about that was because that bill saved lives. You can talk about all the legal arguments, you can talk about mandates, you can talk about a lot of other things, but very simply, that bill saved lives. And that's what 954 is going to do. You can talk about all the rights, you can talk about doctors making decisions, you can talk about the legal aspect of this, you can talk about a lot of different things. But the simple reality is if we pass House Bill 955, we will save babies' lives. I also want to thank the author, Representative McKillop. I appreciate him and his courage for bringing it. It's not easy to bring a bill like this forward. Several of us have been working on some sanctity of life. I call it sanctity of life. I know people like to say it's either pro-life or pro-choice. I happen to support life. It takes a lot of courage for Representative McKillop to do this. And the reason he did this is because, I don't know if he cares if I say this, I hope he doesn't, but I'm speaking from the heart right now, because he was led to do this. I'm going to tell you the truth right here. I have several bills I'd love to pass. I know many of you have bills to pass, but right now, I would be very happy to pass House Bill 954, pass the budget, and go home. As far as I'm concerned, this is the most important piece of legislation that I'm involved in this year in this session. Now, you may not agree with me. Obviously, you don't agree with me, because I know there's lots of people that are going to vote no or take a walk because they don't have the courage to stand up for either be pro-life or to not vote. I have 3 children. My wife and I have had a miscarriage. My oldest daughter, who has 3 children, has had a miscarriage. I know, in working with crisis pregnancies, I know what women go through. I'm not a woman, don't profess to be, don't care to be, but I know the mental trauma that these women have gone through simply by a miscarriage. Cannot even imagine what trauma a woman must go through if they choose to have an abortion. You know, we spend a lot of time here in the General Assembly. I just jotted a few down. Let me tell you some of the things that we focused on here in the General Assembly. Let me tell you some of the great and powerful and wonderful things that we've done down here in the General Assembly. We've recognized the military. We send people overseas that defend this country and come back maimed. We have wounded warriors. We celebrate them. But yet I hear other people saying, we don't want to have that child because they might have a club foot or they might have something wrong. I have several very good friends that are parents of children that you would probably say have a disability. Those parents are so involved in the sanctity of life movement because those children bring them so much joy. I've heard terms today talk about ill-advised legislation. The day that we try to save lives and we classify that as ill-advised, God help us all. I've heard terms today say that a woman makes the worst fear of their life when they hear that that child has an abnormality. Who are we to judge? When did we become judge as to what that is? Back years ago, I was in Florida and I took a company physical. And immediately I got a call that I had to go visit the doctor. I went to the doctor. It was in South Florida. This is 20 or 30 years ago. I had an African-American doctor, a great guy. He comes in and he says that, you know, the insurance company made me call you in to tell you about this abnormality that you had. I said, what's that? He said, your bilirubin content is too high. I said, well, what's wrong? He says, nothing's wrong, but you're outside the norm. And then he joked and said, matter of fact, you're abnormally tall. At 6'5", you're taller than the average white male. The point is we've determined what people are supposed to look like. We've determined how they're supposed to walk. Determined all these things. Let me go on. I'll get off of it here. Let me tell you about some of the legislation. We're working on, do we allow tilapia come into the streams? And this is no disrespect to anybody in this thing, but we voted to put in code to warn people about influenza. We've warned about what we have to do for diabetes. We passed a bill several years ago that said it was inhumane to kill dogs in a gas chamber. We're talking about white-tailed deer. We argued for hours over whether we bait deer before we shoot them. We've talked about sexual predators and what we do for those kinds of people. And then we turn around and pass adoption laws to make it easier for us to adopt people because we want those adopted children because we know there's so many parents that love children and want to have children. And we pass hate crimes and bullying legislation and all these things, but yet today we argue over whether a 2-week period it's wrong to kill a child. It just defies all logic. And I'm not sitting here judging anybody. I don't want to. I'm speaking from the heart. And I hope you will vote for this legislation. If you don't vote for the legislation, that's fine. That's your choice, because you have a choice. But we're talking about a 2 to 4 week time period. You do have choices up to that 20 weeks. I encourage every one of you to support House Bill 954 because it will save babies' lives in this great state. Madam Chair,
Gentleman has yielded the well. The chair recognizes Representative Peak to speak on the bill.
I realize I have a new name. I support my friend and colleague, Representative Doug McGillip, in his bill, HB 954, and just thought that I would share for a brief moment why I am pro-life and why I do support this bill. 25 years ago, a scared, lonely, pregnant woman went to a crisis pregnancy center in Middle Georgia. And after some wise counseling, this woman made the courageous decision, the tough decision, to put her baby up for adoption rather than terminate the child that was inside her womb. On November 4th, 1986, a beautiful 6-pound baby girl was born. 2 days later, Christy Jane Peak came home. Today, Christy is 25 years old and the mother of my first grandchild. So I know personally the benefits of a woman making the very tough, personal, courageous decision not to abort her baby. I fully realize this is an emotionally gut-wrenching decision for many, if not all of us today. But the underlying, and I also realize that as a man, that I will never have to face that gut-wrenching, tough decision that a woman would potentially have to face. But the underlying basis for my support for this bill is that there is life in that womb. I fully support this bill and the protection of life inside the womb that it provides for babies after 20 weeks of conception. Thank you, Madam Speaker.
Chair recognizes Representative Crawford to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, I do not rise today with any pretense of influencing the vote that you will cast in a few moments. I do not have, nor do I pretend to have, that ability. I also recognize and respect that sincere people of good faith can reach different positions on difficult issues. I trust that each of you, when that moment comes, will look to your conscience and cast that vote which you believe to be the right thing. So my purpose today is to simply share with you why it is that I will do what I intend to do. And I'll keep it short because I know you don't want to hear a lot about my personal history. But once upon a time, my wife and I were one of those couples who were told by the doctors, you will never have children, you should consider adoption. But if you want to try some things, there are various treatments that you might try. Made us a referral. We spent the next many months going through a variety of procedures up to and including in vitro. All of them were spectacular and complete failures. It was a very taxing and emotional process, And it brought us to the point that we felt we needed to take a time out. So we did. We agreed that we would take a period of time to be away from it, to reflect upon how we would proceed, and then after a few months, we would make that decision and continue. Well, about 2 months after we made that decision, we learned as a complete surprise that my now 7th grade cheerleader track team daughter was on the way. She was followed about 3.5 years later by my 3rd grade play anything that involves a ball son. When we went to the doctor while my daughter was on the way, we did as many of you have experienced these days. We had an ultrasound. Because of the particular background that we had more than the norm. But one of the things that I remember very vividly was going one day for an ultrasound, and the nurse, as they do, they can print out those images and they give you some that you can keep. The nurse said to us, I'm going to try to get you a profile. I'm going to get you a profile so that you can have that to keep. We never got that profile. You see, every time she repositioned the probe at an angle where she could try to get that profile, my daughter turned her head. She could sense the vibration of that probe, and she kept time after time after time moving about, turning her head to face it, because she could tell something was there. Now, ladies and gentlemen, as we move down the road of life, there are those moments which etch themselves permanently into our consciousness. And they shape all that we do, all that we become from that point forward. That day, that experience of watching that ultrasound monitor was such a moment for me. It has shaped all that I have done since then on this and related issues. And I cannot help but for it to be so. It is a profound part of who I am, of what I am, and what I seek to accomplish. And it is for that reason that in a few moments when the time comes, I will vote yes for this legislation. And I hope that you will join me. Mr. Speaker, I yield the well.
Gentleman has yielded the well. Chair recognizes the chair of the Majority Caucus, Representative Sheldon, to speak to the bill.
Thank you, Mr. Speaker, members of the House. Today, we have heard many tragic stories, and they have definitely been heart-wrenching. Many of these stories, they only represent a very small percent of late-term abortions in Georgia. Last year, when I learned that in the state of Georgia, we are second in the nation in late-term abortions, let that sink in. Think about it. We are second in the nation. You know who else is in that group with us? New York and New Jersey. I don't know about you, but that's not a category that I want to be a part of. So that is why I rise today and ask for your support for House Bill 954. Like I said, we've heard a lot of tragic stories, but I would like to share with you another personal story. 30 years ago, almost 30 years ago, actually 28, I had my first experience in an NICU, a neonatal intensive care unit, when my second daughter was born. We arrived at Scottish Rite Hospital, well, I did, a couple of days after she was born, and Heather, thankfully, was doing great because she was 4 pounds. But her neighbor beside her in the little bed was little Justin. Justin was 26 weeks. Justin was barely 2 pounds, and unfortunately, Justin didn't survive. That was almost 30 years ago. Survival rate for a 26-weeker was very low, maybe 50% at best. Let's fast forward to 10 years ago. and I find myself in another intensive care unit. This time, it's at Gwinnett Medical Center, going to see my very first grandson. This time, he was delivered a few days into 26-week gestation. He weighed 1 pound, 5 ounces. About the size of a pound of butter, just a little bit bigger. And we've heard a lot today about whether the fetus can feel pain at that point and everything. I can assure you that he felt pain. I can also tell you that whenever his mother spoke to him, he calmed, he quieted. He didn't feel pain, he was able to respond to love. He not only responded to her sound of her voice, but also to her touch. Before he was at 1.5 pounds and he's still on a ventilator, she was able to hold him, and so was I. It was definitely a gift that we had, and we treasured those few moments that we would have every day, just once a day for maybe 20, 30 minutes, because that's all he could handle, but the doctors knew that was important. It was important because he was a human being, he was a baby, and he needed his mother's touch. Today, 26-week gestation age has an 80% survival rate. I know a lot of you, when you see these babies in the NICU and all you see are the tubes and the vents, and you think, pity them, poor baby, and how sad. But now at this point, I've had 4 babies in a NICU. I see fighters. I see kids that fight every day to live. I see kids that have grown. My 2 grandchildren that are now 12 and 10 are doing incredibly well. One was 1 pound, 5 ounce. One was 1 pound, 9 ounce. Many of you know that November 29th, we had my 3rd grandchild. I was very excited again, but he was weighed in at 2 pounds, 12 ounces. So we're kind of growing. We're a little excited. But everybody's asked about pregnancies. How do you deal with that whenever the unknown is? My grandson was born November 29th. Today, he's still at Scottish Rite Hospital, over 12, 14 weeks at this point. And do we know what it's going to be like for him? Do we know what next year's going to be? No. But he is an incredible kid. And no matter how small they are, these are people, and they count on us. And that's why today I'm asking for your support for House Bill 954.
Chair recognizes Representative Setzler to speak to the bill. 7 minutes remain, and other speakers have requested time. Representative.
Thank you, Mr. Chairman. It's with somewhat of a heavy heart I'd share briefly that the reality of abortion became clear to me as a 15-year-old in 9th grade when I was in a high school class. And a young woman turned around and looked at me and told me that she had just that weekend made the decision to abort her child. The father was a friend of mine on our high school football team. And I don't have time to do dignity to the story other than she was absolutely shattered. I think all of us grew up on this issue. We kind of mature in our understanding of the abortion issue because it's so important in, I think, in American life. I'll simply want to remind us today, though, and I say this with great humility, that let's not forget that the children in the womb, these children that we see in these booklets provided by the state of Georgia, are living, distinct, and whole human beings. They have their own blood type. They have their own DNA. And as Chairman Sheldon had said earlier, many of them can live outside the womb, outside their mother. In fact, when you look at the neonatal ICUs where the interventions go on, where we spend $15,000 or $20,000 a day preserving the lives of these fragile children, the unfortunate reality in Georgia is that in another part of the hospital, perhaps a hospital that's less than a mile from here, a child that's simply not wanted is undergoing the brutality, which we won't talk about today, but the absolute brutality of abortion. And the only difference between the child in the neonatal ICU, for whom we're spending $20,000 a day to save their lives, and the child that is undergoing the brutality of a D&E abortion is the fact the child is wanted, or the fact that autism wasn't a condition that the parents wanted to raise a child with. Friends, the very same children we treasure in our schools as special needs kids. We treasure with our special needs ball fields. We treasure in our special needs programs and outreaches, which we as legislators, no matter what our party is, take pride in. These same children we treasure in life need us to treasure them in the womb when they're most vulnerable. Mr. Speaker, I know we're very limited on time. Unfortunately, there's the stories of mothers in these difficult situations don't always turn out so well. In 2007, we were right here in session. There was a mother down from Johnson City, Tennessee. She was a mother of three, single mom, lived with her mother. There was family supports for her to have another child, but her boyfriend didn't want to pay child support. And as he brought her down to an abortion clinic that advertises themselves as the leading second trimester abortion clinic in America, she left that facility bleeding to death. She rolled into the Atlanta Medical Center and died in the operating room. This General Assembly sent a letter out, a bipartisan group of legislators sent an inquiry to the Department of Human Resources, who investigated that and found that there was gross misconduct. But the physician who did that to her, who wasn't about providing care, wasn't about those kinds of things, owns abortion clinics in 6 states. That doctor owns abortion clinics in 6 states, killed that young woman, and 1 month later was performing more abortions. That same physician was indicted in December of 2011 for $380,000 of Medicaid fraud and is currently under indictment in DeKalb County. We don't have time to talk about that, but friends, that's the brutal reality of abortion in Georgia, and we have a chance to take a stand for distinct, living, and whole human persons who desperately, desperately need our protections. Mr. Speaker, I yield the will.
Gentleman has yielded the well. Chair recognizes for the final 3 minutes and 5 seconds Chairman Tommy Smith to speak to the bill.
Thank you, Mr. Speaker. I would ask that each one of you, as you vote, think about the fact that the bottom line is that if we pass this legislation today, hundreds of healthy babies' lives will be saved. If we fail to pass the bill, the same number of babies statistically we will lose. I would also ask that you ask the question, if you were a fetus 21 weeks of age, how would you vote on this bill? If you were a healthy fetus and could know what was going on, would you want that protection? I think each one of us in this chamber would want that protection. I ask that you vote for life and vote for this House bill. Thank you.
That completes those who have signed up to speak, except for the minority report and the chairman's time. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Clerk will ring the bell. There is a minority report filed. Minority report filed, and the chair recognizes the minority leader of this House, Representative Abrams, to speak to the minority report. The total time allotted is 20 minutes.
Thank you, Mr. Speaker. I'd like to begin by also thanking you for your largesse in allowing Representative Evans to address this body. On to the matter of 954. Today we've heard testimony based not on speculation or conjecture, but grounded in the real consequences of HB 954. Now, I'm fairly certain that the author will return to this podium and tell you that these stories are not exactly what happens, or that he cannot protect these women. That this has happened in other states, 8 of them, most of whom bills will not take effect, did not take effect until January, but that we must follow what we did in 2007, despite the march of knowledge and science. What he will likely say is that we're just using scare tactics. And on this last point, he is absolutely correct. We are trying to scare you. We are trying to desperately terrify you into recognizing that HB 954 substitutes political opportunism and junk science for medical ethics, medical judgment, and the actual experience of women, their husbands, and their families. This should terrify every person in this body. Our opposition is not grounded in defense of abortion. This is not an abortion bill, despite the title. We recognize the prerogative of this body to decide that they want to outlaw abortion, and if that bill were before us, that would be a very different conversation. But this bill is about the cruelty against pregnant women and their families. This is about fetal torture. This is a travesty of what we as legislators should be doing for the women who deserve our protection in this state. Yesterday in rules, I acknowledged that this body will likely seek to take some action to outlaw abortion. And I asked simply that we make 2 changes. One, that we move from 20 weeks to 24 weeks, recognizing medical science. And secondly, that we exempt from this bill medically futile pregnancies. Every story you heard today was about medically futile pregnancies. No one came to talk about clubbed foots. No one came to talk about fetal anomalies except those that would deny medical life. It is the prerogative of the majority to vote their will, but it is the obligation of this body to vote their conscience. I am one of those strange creatures who's both pro-life and pro-choice. For most of my college career, I worked with the pro-life movement in college. I'm the daughter of not 1 but 2 ministers, and I believe in life. But as a legislator, I searched my conscience, and I also understood that I am pro-choice, because I believe abortion should be safe, legal, and rare, in acknowledgement that the scope of my experience is inadequate to speak for the ways of God or the pain of others. Yet the same body that rushed to outlaw dogfighting 6 years ago in a record amount of time would condemn a woman to carry a dying fetus for 4 months without any recourse. This is not about small anomalies. It is about missing lungs and unformed brains, and my God, about broken hearts. The same body that just yesterday passed 3 bills to update our laws, including one requested by a physician, and to quote him, in order to recognize the best of medical science, this same body ignores that scientific knowledge has evolved since 2005 when the pamphlet on our desk was put on there. In 2005, we didn't have smartphones or iPads, and Pluto was still a planet. But for the sake of argument, let us read from the 2005 publication that the author provided. On page 28, it clearly states that abnormalities occur in pregnancy after the 20th week, and that is the leading cause of maternal death. In 2007, this body acted based on the best information at its disposal. But in 2012, we know better. The same medical journals that we turn to annually in order to update our controlled substance bills said that in 2010, fetal pain begins at the earliest at 24 weeks, not as 20 weeks as originally thought 18 years ago, which is the source of most of the studies being cited. If we can have an entire committee on code revision, why do we insist that the earth is flat when it comes to the science of obstetrics and gynecology and neurology? The author promises that the standard of care will evolve and change to meet the change of our laws, but does he guarantee that fetuses will suddenly grow faster, that this body will suddenly raise taxes to fund more doctors in the rural areas where we don't have them, and that the world will not bend itself to our will? The author will return to this podium and demand that we protect the lives of the unborn. But do we not owe some measure of loyalty to the women who have the sacred and painful duty to bring children into this world? Do we not owe them a measure of compassion that explicitly protects them from becoming walking tombs to the medically futile? Should a woman be compelled to accept the well wishes of strangers in a supermarket who reach out to touch her distended belly while she grapples with the knowledge that the fetus within will survive for mere moments upon delivery? Should she be forced to writhe in the agony of delivery because she couldn't get an appointment in time, or because the labs came back too late? Should the fetus within her be similarly condemned when its brain finally processes pain at 28 weeks and that becomes its only sensation until death claims it? And what of young girls who have their first and only experience of sex from rape and incest, from a betrayal so deep that they often do not speak of it until forced to by someone else who sees it at the 20th week? Now, despite what I'm certain will be the author's protest, this bill does not protect the fetus, because some fetuses will feel pain but not survive birth. And the women we've described will be condemned to their fates because we have threatened the doctor's best medical judgment. Thus, a doctor risks his license if he uses that as the sole medical reason for a procedure after 20 weeks. And in a state that is losing OBGYNs and doctors at an alarming rate, do we as a matter of public policy want to criminalize the act of medical judgment? This is not a cruel body. We have taken time to stand and honor those who have shaped and guided our state, who have made sacrifices on behalf of one or all of us. We as a body are not insensitive to the mysteries of God's plan, to the obligations to match our best intentions with the needs of the citizens we serve. The author admitted that he cannot stop pain and suffering, but surely in this body, he has the means not to cause it. There will be tragedies and there will be tears, he said, but they should not be the legacy of this body. What we, the opponents of 954, ask today is simple. For women who have learned too late that God's plan may not be fully realized, that they be availed of the miracles of his science, that his hands on this earth in the form of doctors be allowed to take the actions that may sadden us but may save them, that we permit doctors to do as we should and as Micah 6:8 commands us. And what does the Lord require of you? To act justly, to love mercy, and to walk humbly with your God. Please join me in rejecting HB 954 in its current form. Thank you, Mr. Speaker. If there are no questions, I will yield the balance of my time to Representative Debbie Buckner.
You have that right. The next member will have 12 minutes remaining. Chair recognizes Representative Buckner.
Thank you, Mr. Speaker. I rise today in opposition of House Bill 954, but not for the reasons that you might think. I'm a public health educator with 35 years experience, and I've worked to preserve life and to encourage people to be healthy in every way that I know how. My beliefs about abortion have been formed for many years and have not changed, just as I'm sure yours are and will not. I believe it should be rare. I believe in the case of rape, in which pregnancy can and does occur, it should be allowed. In the case of incest, which is my opinion, rape of a youth by a family member or a family-like member, or in the case of a health and safety of the mother. I do not believe abortion is a form of birth control, and I do not believe I can make this tragic decision for another woman. It is a decision that should be made between the woman, her physician, her God, and the significant others in her life that she chooses to include. Whether you agree with me on these beliefs or not is not what we're here to talk about today. If it were, I would sit at my desk, listen to all the testimony, vote my conscience, and expect you to do the same. But there are some flaws in this structured bill that could be fixed that we are not fixing. This bill is a way to prevent women from having health procedures that prevent substantial and irreversible physical impairments. It is limiting health care based on an arbitrary timeline of 20 weeks. It does not take into consideration the viability of fetus, and it does not consider lethal birth defects. It does not include mental health or it considers mental health irrelevant. It purposefully causes confusion in the law to change language from a physician duly licensed to practice medicine and surgery based on his or her best clinical judgment to unclear marketing, professional rhetoric, reasonable medical judgment. No, I don't know how you define avert. When will avert be the right time? Could the procedure be done too early and you weren't averting? What is substantial and irreversible physical impairment of bodily function? There are real life situations, many of which we heard from Representative Cooper, of fetal demise. That happens after 20 weeks. There's Potter's syndrome that you don't find out until about after 24 weeks, where the babies are born without kidneys, their lungs don't develop, and they die because they can't breathe when they're born. There is lethal congenital abnormalities such as neural tube defects, where they're born without skulls or brains, and those are not even tested for until 22 weeks. Or if the baby is dead, the mother will have to carry it to term. There's a woman that was pregnant with a couple of twins. One more story that I want you to hear. She was experiencing some minor difficulties from the very beginning of the pregnancy. She started to work, and on her way to work, she became very ill. She didn't feel good at all, and she pulled off the side of the road at the closest gas station and parked her car, and she said, I'll just sit here for a few minutes and see if I can get to feeling better. She thought, maybe I'm getting a cold. Maybe it's just the fact that I'm expecting twins. But she laid her head back in the car and she fell asleep. And when she woke up, it was about 2 hours later, and she was amazed at the length of time that had passed. She went into the gas station and she bought a bottle of juice. She called home and she said, I'm going to try to come back home. I've missed making it to the thing I was headed to, and I want you to be on the lookout for me. It'll take me an hour. Come look for me if I'm not there. The woman drove home in the car with the window down. It was in the winter time. She was trying to keep from being sick on the way home. She